Yes, has it been revoked?
Yes, Your Lordship.
Please, Your Lordships.
Yes.
Lordships, in the present case, I'm also seeking for compensation of 50,000 each for both the detainees.
For that, we will have to go for hearing then to see whether it is illegal or not.
My lord, I'm challenging one order, which is without any authority. I'm not challenging the detention order nor the confirmation order. But there is an order again, which further detained me for 3 more months, which is without any authority. There is no law to further extend my detention. But the government has detained me for 3 more months again.
Now, if we go into that again, we'll have to give them opportunity to file their affidavit in opposition.
No, I'm not, that is in my prayer,
No, that's right.
in my main petition, and they have already
If-
filed their affidavit.
Oh, you filed
Already
already.
filed.
The affidavit, Your Lordship.
Affidavit in
Please
opposition was
complete it.
filed. So what are you saying in your affidavit? Which is the impugned order that the one you're talking about just now?
At page number 35, my lord. After the confirmation order, this order has been passed.
28/4.
Yes, my lord. 28 April 2006. This order is without any authority.
What is your reply to that?
Your
Which
Lordship.
paragraph?
Para 7, Your Lordship.
7. Why do you say it's without authority? Because advisory board had given its views and then it was confirmed.
Yes, my lord.
Yes, Your Lordship.
28 January by that order, confirmation after the report of the advisory board.
Yes, Your Lordship.
That is not contested, but this order dated 28 April 2026 is based on the report of the Additional Director General of Police, not the advisory board, my lord.
No, Your Lordship, that's totally misconceived, Your Lordship.
It is
It's
clearly written
confirmation.
in the order.
Yes, Lordship, this confirmation order was passed after the advisory board report, Your Lordship. Just for reviewing, Your Lordship, we seek the advice of the.
Detention period. In the order, it does not say that it is on the report of the advisory board.
Your Lordship, the order may say so, but Your Lordship, this is based on the report of the advisory board, Your Lordship. This is just
For
for
that, we will
confirmation
have
for
to see
review.
the records again.
Yes, Your Lordship, I have that. And Your Lordship, if I may, Your Lordship, when the
Yes.
detention order has been revoked, Your Lordship, I see no need to adjudicate whether there's validity or correctness in the order, Your Lordship.
No,
This has already
it
been
may be revoked, but that period, that particular period,
3 months I've been
that
illegally
that
detained.
3-month period, if this is found to be illegal, this 15th April, 28th April,
20th April order.
then
But I mean, so carefully, so is we have cost to improve that, see that this is. Then not like was managing of this. This would not. That can be this will go only because only the detention part from the future. So we do something.
if you are insisting on the compensation, then we will have to go for a full hearing.
Yes, ma'am.
Because this detention, you're saying that the 3 months is
Yes, ma'am.
illegal detention.
It's illegal
Mm,
without any authority.
mm. We'll fix it next week and then you obtain the records. Because we will have to see from the records whether, even if the language says otherwise,
Yes, Your Lordship.
if the records show that it was on the basis of the report of the advisory board, then we will see.
No, my lords, till then,
Mm.
they cannot detain me. Because they have already passed the confirmation order dated 28 January.
No,
Based on the
otherwise,
report of
otherwise
the-
it's revoked.
Yes, it's revoked,
Otherwise
Your
it's
Lordship.
revoked, so now.
Based
you
on the
will-
report of the advisory board, they have already detained me for that. I'm not continuing, but here further detention under clause 9F of the PTNDPS, only based on the report of the advisory board, they can detain me. But now here, based on the report of the additional director general of police, they have detained me.
But the advisory board cannot sit again and again, once
No.
the report has
No,
already
my
been
lords.
submitted.
Therefore, they are not.
That will examine, but as of now, your detention order is revoked, so
Yes.
you'll be released from detention,
Yes,
from
Your
NSA detention.
Yes, my lord.
Yes,
So,
However,
Okay.
my lord, because
this
of an
petition
and
is-
that, only on that question of compensation,
yes, my lord.
we'll list it next week.
Fine, ma'am.
Okay. Heard learned counsel for the petitioner, Mr. A. Sophie, so also heard Ms. Inaoli, learned counsel for learned government advocate for the state respondents. So also heard Mr. Z. N. Muli, learned CGC for the Union of India. So, para. At the outset, the learned government advocate has produced the copy of order number CON/PIT NTPS/21/2025/62, dated 23rd, no, which is the order for this particular,
Your Lordship, this is
he
62.
he is
Mustak.
62
MD
dated 23rd July 2026, by which the state government has revoked the detention order of the petitioner and has ordered that the detainee, Mr. M.D. Mustaq, MUSTAAQ, shall be released forthwith from detention under the PIT NTPS Act. Stop. At this juncture, the learned counsel for the petitioner submits that the question of compensation also has to be decided, in as much as the order dated order number CON/PIT NTPS/21/2025/30 dated 28 April 2026, under bracket you write annexure I in the petition, huh? Close bracket, has been passed it without authority and basing on the report of the Additional Director General of Police. And therefore, he has been detained illegally for 3 months with effect from 29/4/2026 till 28/7/2026. So list on 5th. List on 5th August 2026. So on the next date, the learned government advocate shall also produce the official records pertaining to the issuance of the order dated 28 April 2026. It's according.
Obliged.
For hearing item number 2,
Same,
Same order,
order.
but here the order will be
60.
instead of 62, it will be 63, and then same date. And then the name of the detainer will be
I mean,
Amin, AMIN.
much obliged.
Obliged, my lord.
May I please, Your Lordship. My lord, I beg to mention item number 6 on behalf of Mosam Sa, my lord. My lord,
Item 6,
yes, my lord.
on behalf of,
Mosam Sa.
okay,
My lord, I'm informed that pleadings are complete. So let the matter be listed after 2 weeks.
none appears for the petitioner. So learned government advocate, Mr. Tipapong, submitting on behalf of M. Longkumar, submits that the pleadings are complete and the case may be listed for hearing,
Yes, my
for
lord, after
hearing
2
after
weeks.
2 weeks. So list after 2 weeks for hearing.
My lord, again, I beg to mention item number 21 and 22. Here, affidavit is ready and I've sent for waiting, my lord. So kindly allow me 1 week time to file affidavit, my lord.
21 and 22, learned government advocate, Mr. Tibapong, submits that the affidavit is ready and it has been sent for vetting. And accordingly, prays for
1 week time.
1 week time to file the affidavit on behalf of the state respondents. So prayers allowed list after 1 week. Yes.
Much obliged.
Yeah, please, Your Lordship. Your Lordship, I beg to mention hearing item 24. Kindly grant 3 weeks to file affidavit, to file reply to the additional affidavit filed by respondent 1 to 6.
Learned counsel, Ms. Renboni is present. So learned counsel prays for 1 week
3 weeks.
or 3 weeks time to file a reply to the counter affidavit filed by the state respondents. So prayers allowed. Yes.
For respondent number 6.
Respondent number 6 is represented by such and such and has no objection. Learned government advocate, Mr. Tiba Pong is present. Stop list after 3 weeks. Yes.
Much.
Much obliged.
Lordship, I beg to mention item number 19.
19.
Yeah,
Uh,
I've sent back for reactivation of our affidavit now, question.
Hmm.
So 2 weeks time will be granted.
Here state is also a party. State,
Item number 19, yes,
yes, because it
Is
says
that also
Union
part-
of India.
yes.
Learned counsel for the petitioner, Ms. Grace Namki is present. Learned additional advocate general, Mr. M. Kim Song, prays for
2 weeks.
2 weeks time to file the counter affidavit on behalf of the state respondents. Which respondent state? What about union? Have they filed?
Not yet, Your Lordship.
And who is representing Union of India? Yes. Learned counsel, Mr. Mangchung Kongyak appears on behalf of the Union of India.
Please, Your
Any prayer? Yes.
This matter, we also need to file our affidavit.
And has made a similar prayer. State is,
2 to 7.
state is slash, not 2 to 7, okay, respondent 2 to 7. List after 3 weeks is prayed for, yes.
Obliged.
That is Your Lordship.
Hmm.
Lordship, I beg to mention hearing item number 23.
Hmm.
My lord, my senior has some personal difficulties today, so if this matter can be fixed on Thursday,
Thursday, let it go next week.
Lordship.
Learned counsel, Miss Grace Namki praying on behalf of the leading counsel, Mr. Moa Jamir, submits that the leading counsel has some difficulties today and accordingly prays for listing the matter next week. Stop. List next week in the hearing column. Yes. Learned, you are appearing?
Yes, Your Lordship.
Learned counsel, government advocate, Miss Inaholi is present for the state respondents and has no objections. Yes.
Much obliged.
Much obliged, Lordship.
Next, Lordship.
Hmm.
My lord, I beg to mention item 5. I pray for 2 weeks time to file affidavit in reply to the private respondent.
Learned counsel, Mr. Bakrin Chapo appearing for the petitioner, prays for 3 weeks time to file a reply to the counter affidavit of the state respondent, is it?
Private respondents.
To the
That's
counter
it.
affidavit of the private respondent. Private respondent number 8. Number 8. So the learned senior government advocate, Ms. S. Mary is present. Ms. Asina Longkoma is present for the respondent number 8. Yes, the list after 3 weeks as brief. Yes.
Right.
Yeah, please, Your Lordship. I beg to mention item number 13, behalf of Pichano. Lordship, here she's here, 13, Lordship.
Hmm.
Here
It-
she's yet to
It's a
receive
fixed
instruction,
matter.
Lordship,
It's a fixed matter.
but here she's yet to receive instruction, Lordship.
Lordship, if your lordship may kindly go to the previous order, lordship.
Hmm.
They are supposed to provide update regarding whether the petitioner has been regularized or not, lordship.
Whether the petitioner has
Has
been,
been regularized or not. Matters pertaining to regularization and the petitioner completed 30 years
30 years.
on 2024, lordship.
Hmm. that you'll have to comply. Because your affidavit, your memorandum itself provides your OM.
Lordship. You want?
So
Yes.
it is just a matter of instruction, verbal instructions also will do, and on that basis, we can dispose.
Lordship,
Okay.
let's this matter fixed next week.
Learned counsel for the petitioner, Mr. L. Pom is present. Learned government advocate, Mr. Such and such, praise on behalf of.
Bichano,
On
Lordship.
behalf of Pichano Kitan, to list the matter after 1 week, as she is yet to receive the instructions. Stop. List after 1 week. Yes.
Lordship, similar Breyer 14. Here she is yet to receive instruction.
Who's appearing? Item 14, petition.
Lordship here.
This also that 30.
Yes, as per this honorable court's order dated 15th April 2026, the government advocate was directed to come with instructions on the next date.
Yes, similar matter.
Yes, yes. And then on the next day also, it was listed before my Lord Justice Devashish Barua. He stated that since this is a case where a senior citizen is involved and he is languishing without any source of income as such, some urgency may be shown by
Oh,
the-
he has already retired
Yes, my Lord. He has already
after
retired.
serving 30 years.
Yes, my Lord. 35 years.
Item 14, you say learned counsel for the petitioner, Mr. Santiago is present. So learned government advocate, Mr. His name, is submitting on behalf of Ms. Pichano Kitan, praise for listing the matter after 1 week, as she is yet to receive instructions. It is stated by the learned counsel for the petitioner that that the petitioner has retired from service after serving for 35 years.
It was listed twice last week
And,
also.
and on the last occasion, this court had already expressed the opinion that expeditious disposal is required, as the petitioner has not been regularized after serving for 35 years. And in view of the office memorandum dated OM, office OM,
Wait, I have to check.
in view of the office OM dated such and such, the petitioner is entitled for regularization. So at this.
It's 17/3/2015.
17/3/2015, huh? Now petitioner is entitled for regularization and in view of the fact that the petitioner is and is a senior citizen, the matter needs to be disposed of at the earliest. Stop. Accordingly, the learned government advocate is directed to obtain the necessary instructions on the basis of which the matter will be, and the effort will be made to dispose of the matter on the next date. List it after 2 weeks, okay? List after 2 weeks, yes.
Let this be the last chance, if it may kindly be reflected, because it has been.
We have already said that effort will be made to dispose of.
My Lord,
Yes.
I'm obliged.
Lordship, similar prayers 16, 17, and 28. Let this matter come up Thursday, Lordship. For disposal, Thursday.
These are also
Bijano.
regularization,
Lordship.
regularization matter.
Existe menos salary.
16, 17, and
18. No,
16, 17.
16, 17, and Lordship 28.
okay, learned government advocate, Mr. Such and Such, makes a prayer on behalf of Ms. Pichano Kitan, learned government advocate, to list the matter on
Thursday.
Thursday.
Lordship.
On 38, huh? No, 37, in order to enable her to receive necessary instructions. So list on 36, 37, all three.
Lordship. For disposal.
And learned counsel for the petitioner, Mr. Such and Such is present, huh? Yes.
Lordship, similar prayer 18th. Here she is yet to receive instruction, so kindly grant 3 weeks of time to file affidavit.
18 also, same. Who's appearing for petitioner? Mr. Senator present for the petitioner. Here also 2 weeks to receive instruction. Pichano Kitam. Yes.
May it please, Your Lordship.
Yes.
I beg to mention item number 7 and 8.
7.
Kindly allow us 3 weeks time to file a written objection reply.
You are for the respondent,
Petitioner.
petitioner. Reply or written objection? It should be reply.
Reply.
Yes. Reply to the affidavit of private respondent.
Yes, Your
Uh, Learned counsel, Mr. Such and such, appearing on behalf of the petitioner, prays for how much time?
3 weeks.
3 weeks time to file a reply to the affidavit in opposition filed by the respondent number 2.
3 and 4.
Respondent number 3 and 4. Stop. Praise aloud. Learned counsel, learned PP, Mr. K. Angami is present. Mr. Such and such learned counsel is present for the respondent number 3 and 4. Stop. List after 3 weeks as prayed for. Yes.
Much obliged, much obliged.
May I please, my lady, I beg to mention item number 12.
Hmm.
Kindly grant me 3 weeks time to obtain, to file affidavit in opposition.
3 weeks. 3 weeks.
There is-
Any objection?
No objection.
Learned counsel, Miss Ayula, na? Ayula Imchen.
Kitty
No,
Imchen.
oh, Kitty Imchen is present for the petitioner. Stop. Learned senior government advocate, Mr. K. Angami, prays for 3 weeks time to file the affidavit on behalf of the state respondents.
Lordship, we'll be also filing our opposition of, I'm for respondent number 4 AG,
Respondent 4.
Lordship.
Learned counsel, Miss Such and such, appearing for respondent number 4, also prays for 3 weeks time to file their affidavit. List after 3 weeks is prayed for. Yes.
My lord, I beg to mention item 11.
Hmm.
I've received instructions, so may I pray that 3 weeks time may be granted to file my counter.
State is the main respondent or Union of India?
I'm for the state respondents.
No, who are the main respondents?
Main respondents are, no,
So Union has filed?
I have not filed. Item 11.
No, my lord.
No.
Yes.
Learned counsel, for the petitioner, Miss Crovey, so Crow is present. Stop. Learned additional AG, Mr. LT Sangtam, prays for 3 weeks time to file his affidavit. He submits that the instructions have been received. Stop. Learned counsel, Mr. Mangchong Kongyak, appearing on behalf of the learned CJC, has also made a similar prayer.
Jin Yang Pong for your,
Mr. Cheng Pong, please. Praying for 3 weeks.
my lord, if 4 weeks time may be allowed, my lord.
Also made a similar prayer and prays that they may be given 4 weeks time to file the counter. So list after 4 weeks.
Like,
Yes.
may I please,
In order to enable the respondents to file their counter affidavit. Yes.
may I please, your lordship. My lord, I beg to mention item number 9, my lord. I'm gonna mention on behalf of principal, respondent number 1, my lord.
On behalf of,
Yanawati, my lord.
uh,
We also, here we also need to file our affidavit, so I believe this will, yes, my lord. I brief for 4 weeks time, my lord.
Learned counsel, Ms. Such and such is present for the petitioner. Mr. Ching Yang Pom appearing on behalf of the learned CJC, prays for
4 weeks, my lord.
4 weeks time to file the counter affidavit on behalf of the Union of India / respondent number 1. Mr. H. Hussein appears for
I'm for respondent 4, 5, and 6.
respondent
We have
number
already filed our affidavit.
5 and 6. And have already filed and states that they have already filed their affidavit. Government, Nagaland is also there, state government.
Yes,
Yes, are you filing?
2 and 3.
Are
I
you-
also filed.
Also filed. Learned senior government advocate, Mr. Moin Chin, submits that the affidavit on behalf of the state respondents / respondent 2 and 3 has already been filed. So list after 4 weeks. Yes.
Like. May I please, your lordship.
Hmm.
Lordship, I beg to mention item number 4.
Yes.
Your lordship, since my senior is no longer handling this matter, and since the matter has been come up today, so I may be allowed 2 weeks time to get further instruction from the petitioner.
Okay. Mr. Im Longchar,
Yes, Your Honor.
learned counsel, Mr. Sen Such, submits that the leading counsel, Mr. Im Longchar, is not appearing in this matter on behalf of the petitioner. And he prays that he may be given another 2 weeks' time to receive further instructions. Who is appearing for the government? Learned Senior Government Advocate, Mr. N. Angami is present for the state respondents. So list after 2 weeks,
2 weeks.
list after 2 weeks.
Obliged. Obliged, Your Lordship.
Please, Your Lordship. My Lord, I beg to mention item number 26 and 27. Kindly grant us 3 weeks' time to file a reply to the objection filed by the state respondent.
Learned Counsel, Ms. Such appearing for the petitioner, prays for 2 weeks' time. Is it 3 weeks' time to file a reply to the affidavit in opposition filed by the state respondents? Stop. Learned Counsel, Mr. Who's appearing? Government Advocate
Pichano.
Ms. Pichano Kitan is appearing for the state respondent. Stop list after 3 weeks as prayed for. Yes. That is 26 and 27, okay? Yes.
Your Lordship, I beg to mention item 20. On behalf of my senior, Apakichu, if this matter we kindly fix on Friday as my senior is indisposed today.
Item 20. Thursday, what about Thursday? Learned Counsel, Ms. Such and Such, prays for listing the matter on 37, huh? So list on 37, 2026 as prayed for. Yes.
May I please, Your Lordship?
Yes.
I beg to mention item number 15. Lordship, if this matter can be fixed on Thursday.
Thursday.
Yes, Lordship.
Learned Counsel, Ms. Kitty Chin appearing for the petition, prays for listing the matter on Thursday. Stop. Thursday is okay?
Lordship.
List on 37 as prayed for. Yes.
For motion, item number 1.
Please, Your Lordship. Your Lordship, my senior, Mr. J. Goswami, learned counsel for petitioner will be very true busy.
Okay. Yes. Call up something. Call item 2.
Item number 2.
Lordship, in item number 1, I'm appearing online, but my video is not started.
Okay, you submit.
Yes, Lordship. Yes, Lordship. Lordship, this for with a prayer for defreezing my account, Lordship. So far, Lordship, as per the request of the police, the bank authority freezing my account, Lordship. That is why I am before your Lordship.
After freezing, has the information been sent to the magistrate?
No, Lordship, that was not sent to the magistrate.
That is a matter of record. Unless we see the record, we'll issue notice at this stage. Okay. The instant application. Yes. This is the problem with the VC, that's why Mr. Goswami, we cannot hear you nor can we understand. Your voice is cracking up. No,
Your
no.
Lordship, if you, Your Lordship, if you may allow, then I will brief the.
Yes, yes. You do that. Your colleague will submit, Mr. Goswami. Yes.
Your Lordship, this writ petition challenged the arbitrary freezing of the petitioner's saving bank account
Hmm.
by the respondent authorities.
Mm.
Your Lordship, the petitioner's bank account was frozen with a request from the Superintendent Police Mon, Nagaland. However, Your Lordship, this petitioner is neither an accused or suspect in this concerned police case.
Hmm. He's
Yep.
the father of the accused.
Yes, Your Lordship.
So we'll issue notice, okay? We'll issue notice and then we will maybe have to call for the records to see whether the section 106 BNSS requirements have been fulfilled, because after the freezing, the report has to be given to the magistrate as per the section. So we will see. The instant application under Article 226 of the Constitution of India has been preferred by the petitioner praying for defreezing of his savings bank account number 276. You just see from the post title, okay? 27, still ending is 75. Maintained with Indian Overseas Bank, Golaghat branch, comma, branch code 2764, comma, where is the bank? Golaghat. Yes, comma, Golaghat, comma, Assam. Stop. Third, learned counsel for the petitioner, Miss Niwityo Litro. So. Also heard Miss Livika, learned
Your Lordship.
government advocate appearing for
1, 2, and 3, I think I received.
respondent number 1, 2, and 3. Stop. Not 4.
Your
4
Lordship,
also.
Yeah, Your Lordship.
Officer in charge.
Officer, I
Yes,
see,
1,
1, 2, 3,
2,
and 4.
3, and 4. Stop. Para. The learned counsel for the petitioner herein has alleged that the petitioner's entire bank account mentioned herein above has been frozen without notice, comma, without opportunity of hearing, comma, without disclosure of the complainant's particulars or any other reasons, thereby depriving the petitioner of access to his lawful property and affecting his fundamental rights guaranteed under Articles 14, 19, and 21 of the Constitution of India. So, the learned counsel for the petitioner submits that the said freezing has been done in violation of the provisions of section 106 clause 3 of the BNSS. Para. Issue notice returnable in 4 weeks. Stop. The learned counsel for the petitioner shall take steps for service on the respondent number 5 by speed post as well as usual process within 3 working days. So the petitioner shall also supply extra copies of the writ petition on the learned government advocate. So please, after 4 weeks. Yes. We are not granting any interim.
Much obliged.
The registry is also directed to call for the records of
The law.
GR number, you say scan copy of the records of GR number 34/2025 in Nagini-Mora PS case number 3/25 from the Court of Chief Judicial Magistrate Mon. Okay.
Item number 2.
May it please your ladyship. This matter is pertaining to service matter. Your ladyship, the petitioner was initially appointed as a bus driver on a casual basis under the establishment of Sao Chang College, Tuingsang, by office order dated 16/12/1996.
1612.
1996. As per the office order dated 28/08/2017, the petitioner was placed in the scale of pay under the revision of pay 1999. Ladyship, the petitioner, despite serving the department for nearly 30 years, yet has been denied the successive ROP, which is revision of pay, as granted to regular employees, despite performing identical duties. Therefore,
No,
being
your appointment is casual, that's why.
a schedule
Ah.
basis.
That's why the casual employees in Nagaland, they are being paid that ROP, what was that? ROP of 2015, no?
Lordship,
Not 2017.
therefore, being aggrieved, the petitioner submitted a representation to the state of Nagaland, the state respondents.
The problem is in such cases, all similarly casual employees are receiving the same scale. That is the thing.
Lordship,
Anyway, we will issue notice. The instant writ petition is filed by the petitioner who was appointed as a bus driver on casual basis, provide order number HTE/ADMN-COL/9/95 dated 16 December 1996. Stop. The petitioner has been serving on such basis over a period of nearly 30 years, and he is performing the same duties and functions as those performed by the regular grade 3 drivers. What did I say? Appointed as bus driver, na? Performed by grade 3 drivers. However, he has been denied the regular pay scale, and his pay scale has only been revised up to the ROP 1999, thereby depriving him of subsequent pay applications. So, heard learned counsel for the petitioner, Mr. Such and such. Stop. Also heard Miss Livika, learned government advocate, appearing
All the respondents.
for all the respondents. Stop. Issue notice. As learned government advocate has already entered appearance on behalf of all the respondents, no formal notice is called for. However, the learned counsel for the petitioner shall supply extra copies of the writ petition on the learned government advocate list after 4 weeks. Yes.
Deeply obliged.
Item number 3.
Yes,
Is your lordship.
yes.
The petitioner is challenging here, my lord, the order whereby his tender was cancelled, my lord, and bank guarantee was proper for encashment, my lord. Then, my lord, facts
But
are like,
arbitration clause must be there,
yes,
no? In your
arbitration
contract.
clause is there, my lord, but I'm not disputing, my lord. Facts are admitted, my lord, here, my lord. Otherwise, arbitration clause is there. I have also made a statement in the writ petition that arbitration clause is there, my lord.
Acha.
I statement is in my lord in the writ petition, my lord. There is arbitration clause, my lord. No, facts are like this, my lord. Petitioner was awarded with a tender, my lord.
Then how the jurisdiction of this court comes in? It's
Jurisdiction, there is no bar at all. If lordship permits, I can go for arbitration. There is no issue, my lord. But there is no bar for entertainment writ petition if arbitration clause is there, my lord. Because facts are like all facts are admitted, my lord. There is no disputed question of facts.
you are approaching this court against a termination, isn't it?
Termination, my lord,
termination
as
of the
well as
contract.
their action for encashment of the bank guarantee, my lord. But when my lord tender was issued, then petitioner was supposed to submit a bank guarantee. Petitioner engaged one consultant, my lord, who prepared the bank guarantee. Thereafter, the respondent asked the petitioner to renew the bank guarantee. But at the time of renewal, the consultant was not responding. Petitioner gave new bank guarantee, my lord, from its own. It was also verified and executed by the respondents, my lord. Thereafter, it came to notice that the initial bank guarantee was forged, my lord. So when and then they issued so cause notice to the petitioner. After receipt of so cause notice, petitioner came to know that the initial bank guarantee was forged, my lord. Petitioner lodged an FIR also, my lord. It's under investigation.
Lodge FIR against that
The
consultant.
consultant, my lord, who prepared the bank guarantee, my lord.
Hmm.
And this is under investigation, my lord.
Hmm.
And my lord, before the so-called, my lord, a fresh new bank guarantee was given to them, that has been already been accepted by the respondent, my lord.
Accepted.
Accepted, my lord. That has been accepted by the business, my respondent, my lord. And even they asked us to renew this bank guarantee further, my lord.
Hmm.
But your lordship will find it, my lord, page 134. This is the new bank guarantee which they accepted. Their father asked us to extend it, my lord.
Hmm.
Thereafter, they issued a so-cause notice. After receipt of the so-cause notice only, the petitioner came to know about this forgery, my lord. And in
Where is the show cause notice?
page 135, my lord. Then petitioner submitted a reply, my lord, at page 137. Detailing highlighting everything, my lord. Thereafter, my lord, at page 139 is the FIR, my lord, that petitioner lodged against that consultant, my lord. Consultant name is Neil Kant Chaudhary, my lord.
So any fresh tender issued
No, but not
after the termination?
No, my lord, no fresh notice, my lord. And my petitioner, till now, petitioners invested around 1.5 crores investment is done, and petitioners interested to do the work, my lord.
1.5 crore.
1.5 crore, I made a statement in the petition, they have, and my lord, he's interested to do the work, my lord. He's always intended, that's why even when he is ready to fund its additional security, 30 lakhs was the performance guarantee, he is even ready to, my lord, increase it to another 30 lakhs if lordship permits, my lord. To show his bona fide, my lord. Otherwise, he is also a victim, my lord, here.
Hmm.
Otherwise, the requirement was 5% of performance security. You can give 10% also, my lord.
The petitioner herein has come before this court under Article 226 of the Constitution of India, praying for quashing and setting aside the impugned contract cancellation order bearing number 88/06/SW-K/06/26/72/E8 dated 8/6/2026, the order rejecting the representation dated 20/6/2026 and the impugned forfeiture letter bearing number 88/06/SW-K/06/2025-26/78/E8 dated 6/7/2026. Stop. Till the next date, you don't issue the new NIT.
But ma'am,
Okay.
they themselves can do the work also. It is there in page number 141, my lord. Last paragraph, my lord. In the cancellation, they said they themselves can execute the work, my lord.
Page 41.
Page 41, paragraph 4, my lord. They say either for departmental or other agency, they can execute the work, my lord. Paragraph 4.
Page 41.
141, sorry, my lord. Page 140, extremely sorry, my lord. 141. 141, paragraph 4, my lord.
Will now be completed by me through departmental order. So you want that they should be restrained from this?
No,
also?
actually, if required, I can continue the work, matlab, because there is I have no intention to avoid the work, my lord.
Mm.
If required, I can immediately I can give the double security, my lord, if required, my lord.
Mm. Okay, what did I say last line? forfeiture quashing, no? Stop. Para. The learned counsel for the petitioner, Mr.
R.S. Mishra.
R.S. Mishra, submits that the petitioner had been issued a work order for surfacing work at, where is that, at location?
Fine, page 24, my lord. Or page 22 also, my lord, LOA.
24.
22 and 24. 24 is the LOA where description is given, my lord, page 22.
For page 22. For surfacing work, and for surfacing work of providing laying and convection of GSB 15 cm thick, comma, WHM, then you just see from page 22 and 24, okay, that subject matter, no? Till Sewak dash 06 slash 2025 dash 26, okay, starting from surfacing works. We provide letter of acceptance dated 19 January 2026 and 24th February 2026. Stop. It is submitted that deposited a bank guarantee amounting to rupees
30,92,935.
30,92,935. Stop. The petitioner thereafter investing an amount of nearly 1.5 CR, started the work. And while matters stood thus, comma, he was issued with a show cause notice dated 18th April 2026, by which it was stated that the bank guarantee was forged. The bank guarantee submitted by the consultant was forged. Stop. And it was stated in the show cause that if no reply is received within the aforesaid mentioned period, comma, the competent authority would be at liberty to pass appropriate orders. Stop. The petitioner, on coming to know about the said forged bank guarantee, has also lodged an FIR against the said consultant to the officer in charge, Sadar Thana, Lakhimpur Police Station, Lakhimpur District, on 16 May 2026. Stop. It is further stated by the learned counsel for the petitioner that the petitioner had also made a term deposit advice under bracket TDA amounting to an amount of rupees 30,92,935 with validity up to 25th September 2029. And the same has already been accepted, is it, by the respondent authorities? Stop. However, in spite of such acceptance of the term deposit advice, and in spite of the fact that the petitioner had invested a huge amount towards the realization of the work order, comma, the respondent authorities have terminated his contract by
Order date, page 141, my lord.
page 141. By the letter number 88/06/SWK/06/2005-26/72/E8 dated 8 June 2026. Stop. Being aggrieved, the petitioner is before this court. Stop. Pardon. issue notice returnable in 4 weeks. The learned counsel, Mr.
Chingyang Pom,
Pom, on
for
behalf
General
of
Wati.
Mr. Yingang Wati, CGSC, it has accepted notice on behalf of the
Respondent number 1, 2, and
Wait,
3,
respondent number 1, 2, and 3.
my lord.
Stop. The learned counsel for the petitioner shall take steps for service on the respondent number 4, 5, and 6 by speed post as well as.
5 and 6, I have sent them soft copy already. I've already informed them matter is listed today, my lord.
Hmm.
Mr. YP Gupta is there, my lord. So we have served them copy and we have already informed about the matter, my lord.
He will appear for all 3,
Yes, my lord. 4, 5 and 6.
4,
my
5, and 6.
Yes, my lord. We have already started the soft copy to them.
No, but you'll have to give
My-
them the hard
My
copies.
lord,
No?
my-
Don't say speed post, then you just say usual process. Usual process within 3 working days from today. Stop. In the interim, it is directed that the respondents shall not retender the work covered under the contract agreement number CEP under bracket SWK -06 of 2025-26 or take any steps to encash the term deposit advice account A/C number 450354855037 lying with the respondent number 4. Till the next returnable date. That will do.
My lord.
Yes.
Obliged.
For admission, item number 10.
Yes.
Yes, the parties are ready for final disposal.
Final disposal. All parties ready?
Yes. So far as we are concerned, I am representing respondent number 5 to 27.
Hmm.
Perhaps this will be the last item. All others matters have been adjourned, I believe.
No, hearing item 25 is there. Hearing item 25. But parties
But this.
seem to be absent. Okay.
Lordship, last time, at the time of motion, I have submitted the copies of the service rule. Is it, if it is available, I will not supply. If
Service
not, I'll
rule.
give fresh copies.
Which service rule?
The education service rules of 2002 and 2017. If not, I'm giving new copies, no problem. Let me give, Lordship.
It is not there.
I'm getting extra copies. The 2002 rules were holding the field when the respondents were regularized.
Mm.
But then thereafter, a new rule came, 2017, but 2017 will not be applicable in the present case because in the year 2011, when the private respondents were regularized,
Mm.
the rules holding the field was 2002,
2000.
service rule of 2002, Lordship.
These are graduate teachers.
Postgraduate
Oh, okay.
postgraduate teachers under Department of Higher Secondary School, Lordship.
Yes.
Lordship, before I go to the submissions, Lordship may kindly see the order dated 13/11/2024. When the notice was issued, the last paragraph.
13/11/2024.
Yes, 13/11, the last paragraph, it says, my prayer for interim not to promote the private respondent during the pendency of the writ petition was denied. However, the last paragraph say, 13/11/2024,
Yes,
yes.
yes, having regard to the projection, this one.
Yes,
Having regard to the projection made by the petitioners, the court is not inclined to pass any interim order to refrain the respondents from proceeding with the promotion. But however, it is made clear that any promotion that may be made, okay, shall be subject to the final. order.
yes, that is the point. Then your ladyship may also kindly refer to the order dated 12/12/2025.
Sure, sure.
What has happened is the tentative seniority list of 2018, the petitioners were not aware of the covering letter. So of 2025, we were allowed to file an additional affidavit to bring and record the covering letter, Lordship.
Okay, this 11/5/18 letter.
Yes, Lordship. Then finally, 4/6/2026. During the pendency, some of the private respondents are already promoted to the post of vice principals.
Certain
So,
promotions have been made during the pendency of the matter. So an additional affidavit was
yes,
filed.
so the subsequent, keeping in mind the order dated 13/11/2024, I was allowed to file an additional affidavit on 4/6/2026 to bring on record the TPC minutes and the promotion orders. So the additional affidavit, the prayer there should be part of the writ petition. Now, Lordship, kindly allow me to refer to the service rule before I go to the facts. Rule, for the purpose, Rule 7. Rule 7 and 8.
The 2002 rules.
Yes. For the Lordship, kindly see the 7P, source of recruitment, 70% by direct. 70%, Lordship, is by direct recruitment through NPSC. Then, Lordship, may kindly see next page. 30% by departmental special selection from the graduate teachers. Lordship, may kindly see the schedule at page 15. Schedule at page 15 at serial number 4. 70 postgraduate teachers,
70, 30.
70 20 higher secondary schools, Lordship.
Okay, 70 by direct recruitment.
Yes, through NPSC and
And
30 by
30 by
promotion from
promotion
special from the graduate teachers,
from
Lordship.
graduate teachers.
Yes. No, not your own. Not your own, this one. No, Lordship, the petitioners, Lordship, we kindly go to page 64.
64 of your petition.
Yes, Lordship, 64 of the writ petition. Lordship, the petitioners were by a notification dated 7 October 2010. Well, through NPSC, by an order dated, by a notification dated 7 October 2010, the petitioners were declared successful to the post of postgraduate subject teachers under school education department. Then, Lordship, next page. 68. Page 68. By an order dated 21st March 2011, the petitioner were appointed by the government. Your leadership may kindly take note of the 2 days because then Lordship, page 71 is their places of postings. So, my lord, I will not go there into that. Thereafter, Lordship, the private respondents 5 to 27.
Hmm.
You were appointed on contract from the period 19/6/2000 to 29/8/2003. 19/6/2000 to
19/6/2000
29/8/2003.
29/8/2003.
Your ladyship may kindly see page 75. Page 75. Page 75.
Hmm.
Serial number 1 is respondent number 20. If ladyship may kindly mark there. Then
R
3,
R20.
R20. Then serial number 3 is R11. Then serial number 4 is R5. Serial number 5 is R7. Serial number 6 is R26. Serial number 7 is R27. Then serial number 9 is R30. Then next page, page 76 is appointment, initial appointment of R6.
Hmm.
Ladyship may kindly go to page 78. This is the appointment of R8. R8.
Hmm.
Then page 79. Lordship, under the Department of History, serial number 1 is R25. Serial number 3 is R19. Then under Economics,
Hmm.
serial number 2 is R16. Then under Commerce, serial number 3 is R21. Then next page, Lordship, under English, page 80, serial number 9 is R9. Serial number 10 is R12. Serial number 12 is R17. Then page 81 is R10. Then page 83 is R14. Then page,
These are their appointment orders.
yes, initial appointment orders. Then serial number, page 85 is R15. Then Lordship, serial number, page 87, serial number 2. Serial number 2 is R18. Then page 88 is R22. Then page 90 is R23.
R23.
R23. Then Lordship, page 92 is R24. My Lord, I am challenging all these initial appointment orders also. Then page 93, Lordship, out of 25 persons, serial number 13 and serial number 20, who are also similarly situated,
Hmm.
they are already expired. Serial number 16 and serial number 20.
At page 93,
Yes,
16 and
20.
20.
Already expired, since they are expired, I'm not pressing against them. Now, I'm challenging this notification.
Hmm.
Lord, ladyship, may kindly allow me to read this. 10th February 2011. In the interest of public service, the governor of Nagaland is pleased to order regularization of service of the following 25 contract postgraduate teachers under higher secondary schools, such and such, plus other allowances as admissible under rules in force with effect from 18/11/2011.
Hmm.
18/11/2011, 18/1/2011. So effective date is 18/1/2011. Ladyship, may kindly take note of that. 18/1/2011. Then paragraph 2, the inter-se seniority of the above incumbents will be issued separately in due course of time. 3, the period of service rendered in contract basis prior to 18/1/2011 will count for all other purposes such as pension, leave, but not for seniority. This issued with the recommendation of the screening committee held on 14/10/2010 and approval of the cabinet on 21/2011. Now, approval of the cabinet by.
Hmm.
So, my lord, these orders also I am challenging. This is the Lordship, kindly allow me to refer to government affidavit. Two documents. Affidavit of respondent 1, 2, 3, and 4.
Yes.
The issue, this is an office memorandum dated 23rd August 2007, page 12, annexure A. Lordship, in terms of this office memorandum, people who had completed 3 years of continuous service were regularized by a suitability test to the cabinet. Leadership may kindly keep, I will bring on record, the statement of the state government with due respect is not complete because this office memorandum dated 23 August 2007 was further modified by an office memorandum dated 4/4/2008. I will bring on record through a judgment subsequently. So when your private respondents were regularized in 2011, it should be the office memorandum dated 4/4/2008, not the office memorandum of 2007. I will, because Lordship, the office memorandum of 2008 was subject matter of litigation in WPC 145 by Gauhati in 2018. I will bring there there it is reflected. Then page 14. This is the cabinet minutes by which you were regularized. Minutes of the cabinet meeting held on 18/2011. The undersigned is directed to forward herewith an extract of the minutes, agenda 14 of the cabinet meeting held on 18/1/2011 for kind necessary follow-up action. Regularization of contract services of 25 postgraduate subject teachers under higher secondary schools. The cabinet approved the proposal for regularization of the contract services of postgraduate subject teachers under higher secondary school with effect from the date of cabinet decision. However, their contract service will count for pension leave. This action will be taken, immediately intimated to the cabinet seal. So this is the office memorandum on the basis of which the respondents were regularized at page 93. Lordship, in my writ petition, Lordship may kindly turn to page 36, paragraph 5. The relevant paragraph will be the portion will be at page 37, the second paragraph. Paragraph at page 30, paragraph 5 is starting from page 36, but relevant at 37, the second paragraph.
Okay.
It is humbly stated that the petitioner could not obtain a copy of the improved approval of the cabinet by dated 21/2011. However, it is clearly mentioned in condition number 4 of the improved order dated 1/11/2011. As such, the petitioner humbly prays that this honorable court may kindly be pleased to allow the petitioners to imbue the challenge the order dated such and such without including a copy for the ends of justice. So, my lord, I have made a prayer for quashing it, but I did not enclose a copy. And however, that is already there in the government's affidavit at page 14. So, Lordship, the facts of the case in the gist is we were declared successful. Date becomes important, Lordship. We were declared successful by NPA through a NPAC notification dated 7/10/2010.
Yes.
And Lordship, the private respondents are backdoor appointees in violation, you were appointed the horse the rules from the period 19/6/2000 to 29/8/2003. Thereafter, Lordship, after the results were declared, Lordship, for reasons best known to the government respondents, instead of giving me immediate appointment, their regularization process was done ahead of us. When they are very well aware that we were declared, result was declared on 27/10/2010, and a notification and by an order dated 21/3/2011, 23/1/2012, they were regularized with effect from 11.
No.
Page S, which I have just referred. Yes, page 93, by an order dated 11th February 2011, they were regularized with effect from 18/1.
The private respondents.
Yes, 18/1 by a notification dated 11th February 2011, they were regularized with retrospective effect from 18/1/2011.
Effect from 18/1.
18/1, that is the date of
18/1.
decision of the cabinet.
2011.
That's how, that is the issue.
And your appointment was made on
Lordship,
21/3/2011.
21/3. So we were appointed, though our result was declared in
Earlier.
year 2000 earlier, we were declared subsequently.
39 days difference.
No problem. I'll satisfy.
Regularization.
No problem. I'll satisfy by the judgment of this honorable court. How that will be decided.
So that's how they became senior.
That is how they claim themselves to be senior. My lord, on that particular issue, I will satisfy your lordship with two division bench judgments of this honorable court and the judgment of the Supreme Court in due course of time. Under such situation, what law should apply? Now, lordship, a tentative seniority list was issued in the year at page 95. Second, 2/11/2011. Now, lordship, the names of the private respondents appears from serial number 151 to 175.
Serial number
151 to 175.
to 175.
And the names of the present petitioners appears from serial number 176 onwards.
The 151 to 175, 176.
No dispute, lordship. No dispute about that.
Hmm.
Then a final seniority list was issued on 8/12/2011, page 110.
8/12. Page.
Page 110. Lordship, the private respondents, names of the private respondents appears from serial number 131. And below them, the name of the petitioners appears from serial number 156 onwards. There's no dispute about that they were ranked above us in this tentative and final seniority list of 2011. No dispute.
So these two were challenged?
Oh, yes, these were challenged. I have challenged from I have challenged the initial appointment and contract, the regularization seniority list all along. Prayer will be more than 15. Now these are challenged. This seniority list is challenged. Then, lordship, at page 126, there is a new development. This is an order notification to the 23rd January 2012. In the interest of public service, the governor of Nagaland is pleased to order regularization of the 25 regularized post graduates with effect from 14/5/27 to 2007. So the earlier notification by which they were regularized was superseded. Lordship may kindly see at page 2, paragraph 2. This supersedes this.
Okay, okay. So
Department-
11 to 2011 was superseded
Yes,
by this.
yes. And the seniority was given with retrospective effect from 15/4/2007.
Hmm.
Then paragraph 2, this supersedes the department. So the earlier notification of 11/2/2011 was superseded. The other terms and condition remains the same. This is issued with the clearance of the cabinet dated 11/11/2022 as approved by cabinet dated 22/12/2011. Now, Lordship, next page. The 2008 page of NPSC select was, he submitted a representation to the government, which is at page 127. 6 August 2012, page 127.
6 August says.
Merit. With reference to this department notification dated 25/11/2012 regarding the effective date of regularization of 25 postgraduate teachers and in response to the representation of the postgraduate teachers of NPSU 2000 batch for reviewing of the cabinet decision of 21/12/2011, the matter was again placed before the cabinet. The cabinet in its meeting held on 23/7/2012 decided to stand by its earlier decision on 21/12/2011. Therefore, the effective date of regularization of postgraduate teachers as notified shall stand. So the representation was rejected. Thereafter, Lordship. Thereafter, Lordship,
Representation against that, giving them seniority from 14/5.
Yes.
2007.
Yes, Lordship. Representation against page 126. And that was rejected. Now, Lordship, the 2008 page came before this honorable court. Lordship, may kindly allow me to refer to the
Page?
government's affidavit. Respondent number 1, 2, 3, and 4 at page, Lordship, we have just referred to two annexures in the government's affidavit.
That cabinet.
Yes, yes. That same affidavit.
Yes, it's here.
Yes,
Page.
annexure C. Lordship, kindly allow me, one of the type copy starts from page 21. So kindly allow me to refer to the type copies.
Yes. Order dated 22/4/2014.
Yes. I believe since it is a type copy, I believe it is, the government has enough, the next after proper identifications, I trust the government. 22/4/2024. The proceeding under 226 of the Constitution has been initiated by the petitioner seeking the following reliefs. In the premises stated above, it is respectfully prayed that your lordship would graciously be placed to admit this petition, pause for the record, issue a rule calling upon the respondents to show cause, as the way I read amendments, certiorari, and any appropriate order or direction be granted upon cause of causes being shown, be placed to make the rule absolute. Lordship may kindly be really particular with the prayer, because this becomes a code of contention. 1. Caution said as a imbued cabinet memo dated 22/12/2011 in its meeting held on 21/12/2011, giving retrospective date of regularization to the private respondents with effect from 14/5/2007. So cabinet, then next. The imbued cabinet memorandum dated 24/7/2012, deciding that the earlier cabinet decision held on 12/12/2011 shall stand. Imbued notification dated 6/8/2012, giving effective date of regularization of the private respondent 4/28 with effect from 14/5/2007. B, direct respondents to restore the seniority of the petitioner of the private respondent in view of the regularization order by notification dated 10/2/2011 with effect from 18/1/2011. This is the subject matter of the case. Lordship, in my respectful submission in the 5 prayers that we have seen, 4 prayers, the issue is only about the petitioners before this and the 2008 batch had not challenged the legality of the regularization of the present private respondents. They have only challenged the retrospective refactorization of the seniority. Lordship, A, B, and C is about the notifications by which their seniority was refixed with effect from 14/5/2007, where A, B, C, and prayer number B, in the light of the notification dated 10/2/2011, by which the private respondents were regularized with effect from 18/1/2011, their prayer is to restore their seniority. So, Lordship, the notification dated 10/2/2011, by which the private respondents were regularized from 18/1/2011 was not challenged. They are saying that they were regularized with effect from 18/1/2011 by the notification dated 10/2/2011. So the subsequent cabinet decision to be set aside and declared and issue a direction to restore them over the private respondent. That is the prayer. Then, Lordship, page 24 onwards, the operative paragraphs. I have considered the rebel submission, having regarded the amendments made in the petition and the documents attached therewith. It is now apparent that ad hoc contingent employees can claim seniority from the date on which their services were regularized and not a day before. The memoranda, as well as the decision referred to as above, make such provision more than clear. Coming to our case, I have found that the private respondents worked on contract cases till 17/1/2011. They were regularized for the first time only on 18/1/2011. This only demonstrates that the private respondent can claim seniority on the grade of postgraduate subject only from 18/1/2011. Therefore, the notification dated 10/2/2011, which specified that the private respondents can claim seniority with effect from 18/1/2011, is found to be perfectly in tune with the law laid down on such point. In the instant case, there is no dispute over the fact that the petitioners joined their services as postgraduate teachers and been recruited in accordance with the recruitment rules. There is no dispute over the fact that the private respondents were appointed on contract basis, and such appointment commenced from 2000 and some continued for several years. There is also no quarrel over the fact that service of the private respondents were regularized at first with effect from 18/1/2011 by notification dated 10/2/2011 on the recommendation of the cabinet. Being so, for all practical purposes, the private respondents born in the grade of postgraduate teachers with effect from 18/1/2011. However, the cabinet made its resolution against agenda number 16 of the minutes of the meeting dated 21/12/2011 was pleased to regularize the service of the private respondents with effect from 14/5/2007, which was again reiterated by the cabinet in its meeting held on 23/7/2012 by resolution against agenda number 13. But then there is absolutely nothing in record to show what prompted the cabinet to take a position altering the date of regularization of the services of private respondents from 18/1/2011 to 14/5/2007. If it need to be stated here that once the services of the private respondents stood regularized with effect from 2007, they are bound to get benefit of seniority from the date on which their services were regularized, which is never, however, found to be in consonance with the law laid down at this point, which pronounced the service of the contract ad hoc appointment employees can regularize only for the date on which cabinet took decision to regularize the services of such employees. In above view of the matter, I have no option but to conclude that the decision-making process leading to regularization of the service of the private respondents with effect from 14/5/2007 is profoundly illegal, arbitrary, and as such, the same is liable to be interfered with. Consequently, the resolution against the agenda number 16 of the cabinet meeting dated 21/12/2011, the resolution against agenda number 13 of the cabinet meeting 24/7/2012, as well as the notification dated 6/8/2012, are set aside and quashed. The proceeding is accordingly logged. Lordship, may highly appreciate the fact that when the judgment was delivered on 22/4/2014, the Honorable Supreme Court judgment on Oma TV was already holding the field. That no one will be regularized your horse roots. That I will come at a later stage. So then, Lordship, Against this single bench judgment, the respondent filed a writ appeal, but writ appeal was, I think, rejected.
So that 14/5/2007 was squashed.
Exactly. Now, Lordship, now kindly allow me to go back to page 128 to the writ petition. Lordship, by a notification dated 21st March 2014,
Committee was.
a committee was constituted to examine the seniority. Then, Lordship, at page 130, Lordship, the committee come to a finding. Lordship, the last paragraph. The matter was I am reading from the second paragraph. The committee had its meeting at the office chamber of the Commissioner Secretary on 7/4/2014. The meeting was chaired by the Commissioner Secretary. The chairman briefed the members in detail about the case in determining the principle of seniority of the principal, vice principal, and postgraduate teachers of government and higher secondary schools, and deadline given by the Honorable High Court to submit reply by 22nd April 2014 on the above. The matter was discussed in detail by the members. The committee is of the opinion the PNR OM stipulates a regularization of service and contract should be with effect from the date of cabinet decision, whereas the cabinet in its decision dated 21/12/2011 on regularization and contract service of 25 days should be with retrospective effect, and the school education department has issued notification to 23/1/2012 regularizing the service of 25 PGDs with effect from 14/5/2007. The decision of the cabinet dated 21/12/2011 has not brought out any amendment or modification reviewing the stipulation of the prescribing the date of observation regularization with retrospective effect. However, since the cabinet has in its meeting held on 24 July 2012 reiterated its earlier decision of 21/12/2011, and accordingly, the department has issued a notification dated 6/8/2012. The committee has no discretion to differ from what the cabinet has decided. Then thereafter, Lordship, page 132, after the judgment was delivered, 5/3/2015, Lordship, determining the principle of seniority between two groups, parties in WPC 163K. The undersigned is directed to refer to the subject cited above and to say that the principle of determining the seniority of PGT between the contract regularized through NBC 2008 and NBSC WPC number 163K 2012 shall be in accordance with the Honorable High Court order dated 22/4/2012. 14 and 17/9/2014. In view of the above, the High Court order dated 22/4/2015. In view of the High Court order dated 22/4/2014, the department notification dated 6/8/2012 will not be applicable. It simply says, Lordship, that the government notification of 23/1/2012 will not be made applicable. However, Lordship, it is totally silent about restoration of the notification dated 11/2/2011. Lordship, it only says 6/8/2012 will not be applicable. Lordship, may kindly appreciate the fact that when 6/2/2012 was issued, the notification dated 11/2/2011 at page 93 was superseded. Lordship, may kindly see. Lordship, may kindly see at page 126, second paragraph 2, 126.
Yes, this supersedes the department's notification of even numbers.
Yes. That is page 93, by which the private respondents were regularized with effect from 18/1/2011. It simply says, Lordship, the notification will not be applicable, but no notification was issued restoring the original notification of 2011. Now, my lord, with regard to the tentative
Acha,
seniority,
then this 6/8/2012 memorandum is which one? Which page?
page, my lord, at page, lordship kindly, page 1, 6. Lordship, which order?
This, the notification dated 6/8/2012,
127.
page 127. Okay, okay. Okay, so this notification will no longer be applicable.
Applicable,
That's what
that
you
much.
said.
And it reiterates the earlier stand.
Decided to stand by its earlier decision taken on 21/12/2000. Okay, then.
Now, Lordship, with regard to the, Lordship, kindly allow me, with regard to the first tentative seniority list issued on the tentative seniority list of 2011 and final seniority list of 2011, which I have referred, where the date of regularization of the private respondents were shown as 18/1/2011. And our date of regularization, the date of appointment was shown as 21/3/2011. Then, Lordship, in superstition of that, he came up with a notification whereby they were given the date of 2007 and litigation before the Honorable Court. So, my lord, with regard to the 2011 seniority list, when we approached the competent authority, we were informed that in view of the subsequent development, whereby the date of seniority, date of regularization has been retrospectively changed from 2011 to 2017, a new seniority list will be applicable, it will be published, and it has become redundant. Since the date, everything is changed. So that was the information given to us. So we did not pursue against the final seniority list of 2011 in view of that situation. Thereafter, Lordship, in page 134,
One,
135, 134. A tentative seniority list was published. Now, Lordship, the private respondent, name of the private respondents appear from serial number 140 to 163. And the writ petitioners appears from 164 onwards. Now, here, Lordship, the date of regularization of the private respondent is now shown as 11/2/2011.
private respondents shown as
The date of regularization is now shown as 11. Date of regularization is shown as
140, page
11. I'm confusing with the date.
1 minute.
I'm sorry. 18/1/2011. 18/1/2011, Lordship. Instead of 2007, now it is corrected. Now it is shown that.
So this is another seniority,
Yes.
tentative seniority list.
After Lordship, Lordship may kindly appreciate the fact that 2011, then the retrospective, it was changed to 2007, then the litigation decision of the cabinet, then finally it came out with another tentative seniority list.
So here it is shown as 11/2/2011.
Yes. And we are below them. Then Lordship, at page 182. And at 182, Lordship, the covering letter, after I filed, I was allowed I filed an additional affidavit to bring on record the covering letter, Lordship.
This is another tentative.
Yes, the final seniority list, another tentative seniority list. So, Lordship, in my additional affidavit, which I filed in January 2026, it is dated 11/5/2018.
1 minute, page.
The tentative seniority list of 11/5/2018. Page 182.
11/5/2018. Yes.
Lordship, kindly allow me to refer to the covering the additional affidavit. I have filed an additional affidavit in the month of January. It was filed by Aaron Long. On the first page, additional affidavit to file on behalf of the writ petitioner bring a record the covering letter of the tentative seniority list dated 11/5/2018.
1 minute. There are so many affidavits.
Yes.
Filed on 24th June. No,
That is the second one.
that is the
We filed it in January.
31/2026.
Yes, that must be the one. Lordship, may kindly see it, page 5.
Bringing on record that the coverage
Yes.
letter. Okay.
Yes. And next, the covering letter, it's at page 5. Kindly allow me to read tentative seniority list of officers of government higher secondary school education. The tentative seniority list of government higher secondary school department Assam 11/5/2018 is hereby circulated, published for information of all concerned. The list has been prepared after examining all relevant documents available with the department. Objection, complaint against entries in the list should be submitted through a representation supported by documentary proof within 1 month from the date of issue of this memorandum. If no representation is received within the stipulated time, this seniority will be treated as final. Now, in this seniority list, Lordship, the private respondents appears from serial number 134 to 157.
134 to
157.
157.
And petitioner's name appears from 158 onwards. Now, the petitioners had approached the respondents at various occasions, submitting representation in personal interview, and one of the representation which I have annexed at page 220. Now, Lordship may kindly appreciate this fact that in spite of the long delay and issuance of the seniority list as early as tentative seniority list, which he claimed to be treating it as final in the year as early as 2018. Lordship, no third-party interest has been created, Utina. No third-party interest has been created. Lordship, may kindly take note of that. Immediately, right after them, we are below them immediately, and in between, there's no other person and no third-party interest has been created in spite of the delay. Now, Lordship, kindly allow me to refer to the second affidavit, which Lordship has just referred to June 1.
Yes.
Lordship, may kindly turn to page 7. My lord, a TPC was held on Page 8, Lordship will see, Lordship will find. A TPC was held on 9/4/2026. And which was submitted by a covering letter at 9 April 2026. Now, Lordship may kindly see, in this case, Lordship may kindly see from serial number 12 onwards, the private respondents. Lordship, kindly take note. Private respondents number 12 to 17, 20, 21, 23, 25, 26, and 27. Serial number. You were recommended by the TPC for promotion to the post of Vice Principal, Lordship. Then next page, page 11. Thereafter, Lordship, by an order notification dated 1st June 2026 at serial number D.
Serial number.
The post from the post of senior PhD to vice principal. Lordship, from serial number 2 to 13. You were promoted. Page 12, serial number 2 to 13.
Okay. 2 to 13, they are all the private respondents.
Yes, that is the same respondents, 12 to 17, 20, 21, 23, 25, 25 to 27, which I have just mentioned.
They are promoted as vice principal.
Yes, I was promoted as under recommendation of the TPC. Now, Lordship, in view of the order passed by this honorable court on 13/11/2024, any promotion to be made subjected to the final outcome of this case, Lordship, I have filed this additional affidavit. So that may kindly be taken into consideration. Now, Lordship, before I go to the legal submissions, kindly allow me to read few paragraphs. Then, my lord, I'll confine to the law only. Lordship, I'll kindly allow me to kindly take note of this paragraph 7, 8 in my read to the writ petition.
In the
My
writ
lord,
petition.
after I read this few paragraphs, I'll only confine to the judgments. Paragraph 7, 8, 15, 24. Can you allow me to read these four paragraphs to save time, Lordship? I need not make lengthy submissions. Page 40 onwards.
Yes.
May I read, Lordship? That it is respectfully stated that at some time in the year 2012, the petitioner came to know about the impaired cumulative seniority list dated 2/11/2011 and the final seniority list of 8/12/2011. The petitioner, being highly aggrieved, had approached the competent authorities for wrong inclusion of the private respondent in the seniority list and their superstition. You informed the seniority list of 11 and 2/11/2011 and 8/12/2011 with regard to promotion. With regard to the petitioners and private respondents have become redundant and not applicable in view of the notification dated 23/1/2012, whereby the date of the regularization of private respondents were changed with effect from 14/5/2007 and not 18/1/2011 as provided in the tentative seniority list and final seniority list. The petitioners were informed by the competent authorities that in view of the notification dated 23/1/2012, a new seniority list will be published in due course of time. It is respectfully stated that a representation was submitted by the VGTs of NBSC 2008 for reviewing of the decision of 2012-2011, whereby the cabinet has changed the date of the regularization of the private respondents of 18/1/2011 to 14/5/2007. Thereafter, the notification dated 6/8/2012 was issued by the government, reiterating the effective date of the present private respondents reviewed by the cabinet with effect from 14/5/2007. The date of regularization of the private respondent has become a subject matter of the PBC number 163/2012. Thereafter, by a notification dated 21/3/2014, the state government had constituted a committee for determining the principal seniority of vice principal PGDs in accordance with Rule 17 of the Service Rules of 2002. Thereafter, by a meeting minus dated 7/4/2014, the committee has decided that in view of the decision of the cabinet, the committee has no discretion to differ from what the cabinet has decided. Finally, by imbued memorandum dated 5/3/2015, in compliance to the direction of the Honorable High Court, it was decided that the department will not be a sixth notification dated will not be applicable. Accordingly, the imbued notification was revived, whereby data authorization is 15/1/2011. 8. The petitioners respectfully state that in pursuant to the order dated 9/5/2016, a meeting above was called by dated 17/5/2016 by the Joint Director and Chairman for the preparation of the entity seniority list for the higher secondary cadres of on 24/5/2016. Thereafter, minutes of the committee on preparing of the proposal of the seniority list of higher secondary education as on 27/2016 was prepared. The criteria tools used to sort out the seniority list is purportedly on the principles governing the fixation of seniority in accordance with service rule, government of notification, orders and notification memorandum from time to time to count the seniority. With regard to the present privy respondent, the committee has decided as under, in respect of PGDs who were appointed on contractual basis and subsequently regularized for recommendation of screening committee, the relative seniority will be based on date of regularization of and government orders notification thereon. The aforesaid criteria tools adopted the committee with regard to privy respondents. It was in clear violation of Service Rule of 2002. It is humbly stated that it is an established principle of law that Service Rule shall prevail over such orders and notification, if any. In the proposed impugned entity seniority list of 2016, the name of the privy respondents appeared in 140 to 163, and whereas the names of the writ petitioners appeared from 164 onwards below the privy respondents. The proposed seniority list was never published circulated to all concerned. Thereafter, the impugned seniority list of 2018 was proposed by the committee chairman on the same principles as provided in the tentative seniority list, where the names of the respondents appears from 134 to 157, whereas the private petitioner from 158 onwards. It is respectfully stated that the seniority list of 2016 and 2018, it was proposed by the Joint Director, Higher Technical and Chairman of the competent authority. My lord, this I'm conceding because I was not aware of the covering letter. Now, my lord, page 44, last paragraph. In view of the it is respectfully submitted that in view of the statements as highlighted in paragraph 7 related to this petition, in view of the peculiar facts and circumstances, there was no delay in filing the writ petition. There are sufficient reasons for the same. It is further submitted that when a persons are illegally appointed in clear contravention of the service rules, seniority are assigned to the person not according to the rules and procedures. Since non-adherence to the relevant rules goes to the very root of the matter, technical consideration such as delay should pave the way to consideration of merit. Then Norshim kindly allow me to read paragraph 15. The petitioner respectfully submitted in accordance with the rules. There are only 3 notes of appointment, direct recruitment, special selection, promotion in accordance with Rule 7 and 8. The present private respondents were not appointed through any of the above prescribed modes of appointment. As earlier stated, the services of the private respondents were regularized by a notification dated 8/11/2011. However, regularization is alien to the rules and therefore illegal. This mode of appointment regularization is divorced the rules and the constitutional schemes. It is respectfully stated that the illegality in relation to service of the private respondents had continued from the date of their initial contract appointment, which was ex facie illegal. The illegal regularization till date. A continuous process, Lordship may kindly take note of this word, continuous process ultraviolates the constitution and the rules. Therefore, it should not be permitted to continue enjoying such unjust and illegal gain. The state government must be prevented from acting arbitrarily, discriminatory and illegal actions against the petitioner. It clearly shows that the cause of action had arisen from the date of their illegal appointments, which continues till date. Then Lordship may kindly allow me to read paragraph 24. That it is respectfully page 24, paragraph 24, I'm sorry, Lordship, page 54, paragraph 24. That it is specifically stated the subject matter of the case in WPC 163K of 2012. The writ petitioners had challenged the notification dated 23/1/2012 by which the date of regularization of the private respondents were changed with effect from 18/1/2011 to 14/5/2007. And this honorable court by the judgment and order taken judgment had interfered in the notification dated 23/1/2012. However, in the present case, the petitioners are challenging the illegal regularization of the private respondents by the ambient notification dated 11/2/2011 as violated of the civil soul and the constitutional scheme for recruitment in government service. As such, the subject matter of the present petition is totally different from the issue raised in the petition number 163K of 2012. Now, Lordship, the respondents. The respondent, the official respondents as well as the private respondents. Lordship, in their affidavit in opposition file, had raised 4 identical issues to my respectful submission. Of course, when in the course of their submission, you will be giving highlighting more points, but the 4 general points which I got.
That may be live with me.
Which I will summarize.
No, according to him, therefore.
Yes, because
According
accordingly,
to
my
you,
lord,
there may be more.
yes, there may be more, but 4 important issues, which I will try to counter also in my submission. Number 1, Lordship, you have made a submission that you will regularize. There is nothing wrong in the regularization. You will regularize in terms of the scheme of
Scheme framed by the government.
2007, and we have no grievance again. We have not challenged the scheme, so I have no locus standi. 1. Secondly, you meant another round of legal issue raised. I'm not going to the factual issues. Is that the regularization, everything is already decided, and finality is attained by the judgment of this honorable court in the C-163K of 2012. Thirdly, Lordship, locus standing. They are saying that you were regularized 31 or 39. Yes.
18/1/2011.
You were regularized ahead of us, that we were not born in the cadre when you were regularized in service. So I have no locus standing to challenge your regularization. And fourthly, delay in latches. These are the main line of attack which I could sense from their affidavit in opposition.
That was the
There may be more.
That was the main thing which struck this court's mind also.
Yes,
The delay.
I'm coming. I will come.
Yes.
I'll come to those. There may be more. There may be more grounds, but these are the main 4 grounds which I thought I should address.
Okay.
Now, Lordship, I have. Yes, yes. Wait, okay. No, I shall only confine to the judgments, Lordship. And I hope I shall be able to satisfy your Lordship while referring to the judgments on this, on the issue of delay and other issues.
So far as the judgments are concerned, my learned, if I'm just putting a suggestion, because ultimately Lordship has to go through the same judgment as and when Lordship goes to write the judgment. So on this point, I have this judgment and then relevant.
And the relevant
paragraphs are-
Relevant, I have
To save
no,
time, I think. that
No,
we-
I had prepared a note, but Lordship, in some of the judgments, especially on the issue that I was not born in the gather before on the locus standing, that I was not born in the gather when you were regularized. There are 3 judgments. So there I would like to show the facts. Exactly like the case. In fact, my learned friend was one of the counsel in that case. I'll show him.
Same more.
Yes, same way I'll
That is a very judgment. But private respondent did not go.
Lordship. Now, my lord, on Uma TV, Lordship, I need not make a submission because Lordship, I'm relying on Uma TV page paragraph.
Maybe is but clarified so many times by the Supreme Court.
But since Then
Extend
Lordship,
Uma Devi, there has been so
no,
many
no
judgments.
problem. Then Lordship, the next case, WPC 145A, my Lordship may kindly see at page, paragraph
The
20.
WPC,
145, Lordship, I have made it in the WPC 145 K of 2017.
yes.
Lordship, at paragraph 20, my lord, this office memorandum of 4/4/2008 is reproduced, which is a, then Lordship may kindly see the first paragraph, in partial modification of the department memorandum dated 23rd August 2007. Then the 23rd August 2007 was modified by office memorandum dated 4/4/28, the regularization scheme, and you were regularized in the 2011. So Lordship, it appears the government forgot to enclose the office memorandum of 2008 4/4 because this is the one which was holding the field when you were regularized. And Lordship, this honorable court has given us the linear single bench come to a conclusion that the office memorandum of 4/4/2008, by which people with contrained ad hoc appointed with 3 years continuous service was found to be violative of Article 14 and 16 in judgment in Oma TV, Lordship. Then, my lord, a writ appeal was filed. Next page. Next case. Writ appeal 16K of 2018.
Yes.
Yes. Now, Lordship, may kindly allow me paragraph 21 and paragraph 21 onwards.
Paragraph
21. The learned single judge, the division bench has upheld the learned single judge judgment, saying that the office memorandum of 2008 is violated by Oma TV and Article 14 and 16. Now, Lord, the next judgment. This is my lord, this is a case of judgment of 16/4/2026. Madan Singh versus others. Yes. This is a judgment dated 14/6/2026. Lordship may kindly see paragraph 2 to 6. Here, Lordship, in the state of Haryana, similarly like Nagaland, paragraphs, my lord, the written paragraph, facts of the case is at paragraph 2 to 6. I'll be relying on paragraph 19 to 21 and 25. But Lordship may kindly see at paragraph 3 to 6. Lordship, 3 to 6, people with 3 years, state of Haryana came out with 2 schemes. People who have regular service of contract service of 10 years. And similarly, like the state of Nagaland, people who have a continuous service of 3 years. And exactly like Nagaland, Lordship, you regularize without any advertisement, you horse the rules. That was challenge. Now, my lord, to save time, I'm not reading the facts, but to be fair, I'm giving the relevant facts statement that paragraph 2 to 6 is the facts. Now, paragraph 19 onwards. Lordship, the clarification Lordship were highlighting is all here. Much emphasis has been placed on the aspect that despite the policy of regularization being required to be undertaken as a one-time measure as enunciated in paragraph 44 of in Oma TV, the state government has sought to undertake this exercise of regularization belatedly and in a perpetual manner. In this regard, we may refer to the observations of this court in ML Kesari. Lordship, I'm skipping this. Then, Lordship, kindly allow me to come to paragraph 20. Thus, given the object behind the issuing of the notification dated 6/6/2024 and 8/6/2024, which is primarily to grant the benefit of regularization to those remaining group B, C, and D in ad hoc contractual daily wage employees, which benefit have been granted to similarly placed employees pursuant to notification dated 7/3/2096. We do not find any reason whatsoever to hold the notification that are liable to be quashed as being arbitrary, illegal, and contrary to the law by this court in various decisions. validity of 7/7/2014 and 7/7/2014 is the General Administration Department of Government have come up with a policy decision to regularize the services of EC&T. This policy was, however, slightly distinct from the notification of 16/6/2014 and 18/6/2014. Significantly, that what was provided for was that the services of ad hoc employees who had or were complete of 10 years of service in the future date of 13/12/2018 were to be regularized if her original appointments was not made through the process of advertisement and interview. The criteria prescribed for possessing the requisite qualification, the work discharge was to be on a sanctioned vacant post at the time of initial agreement and also at the time of regularization. See, the reservation policy as applicable ought to be borne in mind. No relaxation of prescribed criteria. In our view, the notification dated 7/7/2014 seek to regularize the engagement of such ad hoc employees who were not initially engaged through the process of advertisement, nor after facing interim review. Such stipulations were not found in the earlier notification dated 6/6/2014 and 18/6/2014, which we have held to be valid. There is no justification placed on record by the state of Haryana as to whether the services of such ad hoc employees who had not been engaged on the basis of any advertisement or interview were sought to be regularized, that too by taking into consideration a future cutoff date of 31/12/2018. The claim of being engaged such sense in advertisement itself gives rise to doubts as regards the manner of engagement. Absence of any record whatsoever of the matter engagement does not inspire any confidence in such process. Thus, such ad hoc employee has not faced any interview is another relevant feature. Further, there does not appear to be any rational basis for fixing a future cutoff date which is beyond 4 years from the date of notification. This would indicate that even when it was possible to initiate a process of recruitment after issuance of notification dated 7/7/2014 by virtue of the ambient notification, number of such posts would have been filled through regular recruitment were not liable to be advertised. The intent was to accommodate such ad hoc employees who come to be engaged, albeit temporarily in the absence of any public advertisement or interview. We see no justification. We see no reason to uphold the validity of the notification of 7/7/24 since the intent to regularize the service of ad hoc employees who were engaged without any advertisement, without any advertisement, without being interviewed. Then, Lordship, conclusions, page 23, paragraph, having found that the notifications were valid, the High Court was not justified in holding otherwise. The service of the beneficiaries of this notification would stand protected. In other words, in terms of the spirit of such and such, the service of the employees of BC&T who satisfy the requisite criteria as prescribed are entitled to be regularized in terms thereof. The subsequent notification are found to be arbitrary and illegal. Under the state notification, the ad hoc employees of Group BC&T who were in service of since 31/12/2008 were intended to be regularized. A period of almost 12 years has elapsed since the issuance of this two notification. It is a specific stand of the government that even after excluding the ad hoc employees from Group BC&D who seek the benefit of this notification of the post advertised will be affected. Further, it is informed that such employees have now gained sufficient experience and are likely to have settled in life with the passage of time. It is true that when the challenge was pending before the court by an interim order, it was directed the order of regularization would be subject to the final outcome of the said proceedings. When the present proceedings was pending in this court, an interim order directing status quo was passed. It is thus clear that this ad hoc employees continue in service in their service are still being utilized by the Haryana in the peculiar facts and circumstances under Article 144. We deem it appropriate to permit Group B, C, and D ad hoc employees who are continuing in service and who seek benefit of notification be continued in service. They shall, however, this is important, they shall, however, be placed at the lowest pay scale that is admissible to the post held by them in terms of the decision. So, Lordship, in view of the long service, some of people who have served for more than 10 years, they were allowed to continue in service on the bottom of the seniority list, in the lowest grade. Now, Lordship, Now, Lordship, kindly allow me to refer to TWP versus Rafakitin. Lordship, I have already made a paragraph 19, 20, and 21. It is already there in the note, Lordship. In this note, it is already there.
Okay, okay.
But the judgment, but I have already submitted the book.
Okay. State
Lordship,
of UP versus?
1987 Supply SEC 401.
Okay. Yes.
I'll only refer to a few. Lordship need not make any note because it is already there.
Hmm. Hmm. Yes.
Lordship, kindly
The
allow me to
candidates who were appointed.
They form a
they
separate
host the
class.
rules. Hmm.
divorce the rules. Lordship, my lord, paragraph 15 in 19, Lordship, at page 423.
Okay, that is the main point.
Lordship, but
They
Lordship,
form a separate class.
yes,
Page 423.
yes. 423, paragraph 18 and 19.
Hmm. Yes.
And Lordship, page 24, paragraph 24. And on the right hand, they are saying that you should be given the bottom of the seniority list. Seven line from the bottom, from the top. Having regard to the two facts and circumstances, we have the opinion that the view taken by High Court on the administrative side in the state government that the unplaced candidate of 1970 should be assigned seniority below the last candidate of 1972 examination appointed to the service in just and reasonable manner. Page 425. Paragraph 24 on the right. Lordship, 1, 2, 3, 4, 5, 6, 7, 8 line from the top. 425 page.
Okay, assigned seniority below the last candidate.
Lordship, the seniority dispute between 1970 appointees and 1972. The court gave a direction that people who are irregularly appointed form a separate class, and the 1972 page should be below the 1970 page should be in the below the seniority of 1972 page. Obviously, 1972 were appointed earlier prior to 70. Then Lordship, next 2011 3 SEC 436. State of Orissa versus Mamda Mohandi. I'll only refer to one paragraph.
36.
Lordship may kindly see, if Lordship may kindly see, see the head note at page paragraph 35 from 451. Appointment without advertisement. 451.
Yes.
Employment without advertisement. Then Lordship at page paragraph 36. Any appointment made without inviting, without advertisement, even by inviting from employment exchange, is violative of 14 and 16. Then Lordship, 2002 SEC 482. Lordship, I read only paragraph 12. One of the definition of employment or appointment is defined here. Lordship, may kindly allow me to paragraph 12.
Yes.
The Article 16, which finds place in Part 3 of the Constitution relating to fundamental rights, provides that there shall be equality of opportunity for all citizens in matters relating to employment and appointment of any officer under the state. The main objective of Article 16 is to create a constitutional right to the equality of opportunity in employment in public services. The word employment or appointment cover not merely the initial appointment, but also attributes of service like promotion, age of age of superannuation, etc. The point I'm making is, Lordship, once the route is bad, then it affects everything. So, my lord, illegal appointment, the word illegal employment, illegal appointment includes not only the initial appointment but promotion. It clearly says, Lordship, if the all subsequent developments or the words employment or appointment cover not merely the initial appointment, but all other attributes of service like promotion and age of superannuation, etc. So everything comes. Then, Lordship, 2006, 5 SCC 493, paragraph 13 and 18. Paragraph 13 and 18, Lordship, regularization is not a mode of agreement. My lord, that is the two relevant paragraphs, 13 and 18. Regularization is not a mode of agreement. Then, Lordship, 2011, 14 SCC 77010, page, paragraph 107. My lord,
Davinder Pasing.
yes. Lordship, may kindly allow me, page, paragraph 107. Illegality strikes at the root of the order. Page 810, paragraph 107. May I read, Lord?
Yes.
It is a legal proposition that if initial action is not in consonance with law, all subsequent inconsequential proceedings will hold true for the reason that illegality strikes at the root of the order. In such a situation, the maxim such and such, meaning thereby the foundation being removed, structure, work, false, comes into play and applies on all scores in the present case. Then, Lordship, 2013, 2 GLD 1011, paragraph 41 to 45. Monia Daipodia, Lordship, I'll read only one. Lordship, I am reading page 1023. I am reading 3 paragraphs. Last,
Robul Sarma, this case.
Lordship, no.
Monyo
Monyo Doibotia.
2000, no, this is not right. 2013, 2 GLD.
2013, 2 GLD.
One zero
1022.
222. Yes.
Lordship, I'm reading from paragraph 43.
Mm.
An important underlying principle of decision of revocating is that even when an account of lapse of a long period of time, Lordship, may kindly appreciate that fact. Appointment made to a service in breach of relevant recruitment rule is not set aside in court. Such irregular appointees shall not be allowed to steal a march over the regular appointees. For us, reiterated in revocating, an employee must belong to the same stream before he can claim seniority vis-a-vis others. Those appointed regularly belong to a different stream and he cannot claim seniority vis-a-vis those who may have been regularly and properly appointed. Following the principle of law as indicated above, it is possible that without setting aside in quashing the appointment of any irregular appointee, the court or tribunal may direct the appointing authority to treat a regular appointee in service through appointed letter. Well, this is important. To appointed letter in point of time, then the irregular appointee are senior to the irregular appointee. In other words, an irregular appointee, particularly if his appointment suffers from arbitrariness, malafide, and colorable exercise of powers cannot be allowed to gain seniority over a irregular appointee, for he cannot be said to belong to the same stream, even if the appointment of the irregular appointee is prior in point of time and is not disturbed on account of long period of service which the irregular appointee might have put in. In the result, for the foregoing reasons, the judgment and order dated under appeal were hereby appealed subject to the modification that the appointment of those who are completed as private respondents in the writ petition would remain undisturbed, but you would be made to ranks in the gradation list junior to the writ petitioners or the private respondents. Lordship, this is before division bench. Before the learned single bench, Lordship, even the initial appointment were set aside, but that was modified. But Lordship may kindly see the issue of delay also was addressed there. Now, Lordship, my Lord, I have given two photocopies of the judgment. Lordship, may kindly allow me to refer to that, to division two.
Writ appeal.
Yes, writ appeal 17 of 2018. Lordship, kindly allow me to read from paragraph 3. Kindly allow me, because facts are exactly the same. So, my Lord, kindly allow me to refer. The matter, paragraph 3. The matter pertains to seniority. The writ petitioner filed the PPC 299, 2017, challenging the final seniority list of gazetted officers of staff of the NBC as on 1/1/2014, issued by the memorandum dated 5/11/2017, wherein the writ petitioners had been placed below the respondents number 2 to 5 in the post of LDA. The case of the writ petitioner was that in pursuance to the advertisement dated 6/9/2010, issued by the NPSC, he underwent an examination along with other candidates for appointing the 3 vacant posts of NPSC as per Nagaland NPSC regulation of 2008, hereinafter referred to as 2008 regulation. He was appointed as LDA and the NPSC on the recommendation of the NPSC by way of direct recruitment by order dated 11/5/2011 with effect from 18/5/11 with effect from 11/5/2011. The private respondent numbers 3 to 5 on the other hand were initially appointed as LDA on temporary contract basis in the NPSC in the year 2009 to 10 sans any selection process, and they were regularized in the LDA in the year 2011, a few days prior to the appointment of the writ petitioner as LDA. The further case of the writ petitioner was that 2008 regulation applicable to LDA did not provide for appointment by way of regularization, by way of direct recruitment. That is, Lordship, with regard to the rules, I did not refer to those. Then kindly allow me to read from paragraph 14, the operation. 14, the writ petitioner underwent a selection process in pursuant to the advertisement dated 6/9/2010, on the basis of which he was selected and appointed as LD and the NPSC as per regulation 2008 regulations. However, the private respondents did not take part in the selection process examination for direct recruitment as LDA in pursuant to the advertisement dated 6/9/2010, though they were already working on temporary contract basis at a relevant point of time and probably had knowledge of the advertisement. The writ petitioner in paragraph 22B of the writ petition has stated that previous respondents were regularized by order dated 3/5/2011, while the result of the examination undertaken by the petitioner for the filling up of the post of LDA had been declared on 5/4/2011. This fact has not been controverted by the respondents. We fail to understand as to why there was a sudden hurry on the part of the NBSC to regularize the service of the private respondents, albeit illegally. The pleading shows that the private respondents three have been regularized as LD after completion of 2 years, 3 months contract service, 1 year, 6 months for respondent such and such for respondent number. Then a single judge has considered this aspect of the matter, and in conjunction with the memorandum dated 4/8/2008 is issued by the government of Nagaland, which provides for regularization of contract ad hoc sanction appointment against sanctioned posts. The above OM dated 4/8/2008 states that any contract ad hoc employees who have completed 3 years of continuous service on ad hoc cases will be eligible for regularization against sanction posts. Though the Learned Council for respondents submit that the said OM 48/2008, which has been issued by the government of Nagaland, is not applicable for regularization of employees under NPSC, the respondents have been able to show produce OM rule to justify the basis for regularization of service of the respondents. It is settled law that source of power must exist for its exercise. However, the only source of power relied upon but the NBSC for regularizing the service of respondent number 3 to 5 by NBSC is Regulation 31 of the 2008 regulation. This section, in our view, cannot be applied for regularization of the services of respondent number 3 to 5, as the same cannot be read in isolation, and also due to the fact that the same does not provide for regularization of contract employees. As no provisions of 2008 regulation provide for regularization of contract employees, we have to consider due that the regularization of the private respondent was illegal, as there was no power conferred upon the NBSC to regularize their service. With regard to the stand taken by the NBSC that the writ petitioner did not challenge the promotion of the private respondents as UTA, which was done in the year 2014, the promotion of writ petitioner in the year as UTA in the year 2016, as such, he could not have challenged a final seniority list dated 15/11/2017. We find that there is no infirmity with the writ petition challenge the seniority list dated 15/11/2017 without making a challenge to the promotion of the private respondent to the post of UTA. It is true to the fact that the final seniority list in staff of the NBSC was met with regard to their posts on 1/1/2024 when the petitioner was private respondents. We do not find any laches and delay in filing the writ petition in view of the fact that the final seniority list of officer and staff as on 1/1/2024 was issued by NBSC on 15/5/2015. The writ petition was filed in the year 2017 itself. Lordship, kindly allow me to skip the judgments. My Lord, kindly allow me to read paragraph 19. In the present case, the private respondents having been appointed in violation of 2008 regulations, which according to Learned Council for Respondents is the only regulation applicable to the NBSC for appointment of LDA, there can be no right in favor of the private respondent in respect of seniority over writ petitioners, as apex court in such and such has held that no seniority given a retrospective effect from a date when the employee has not been born indicated, the seniority of the writ petitioner would have to be considered from the day of appointment, that is 15/5/2011. Two, we find that the appointment of private respondent is violation of the law in the apex court in state of Orissa, Mr. Mamta Mohadi, and the regularization is also illegal. We did not make any observation or direction with regard to the appointment of the private respondents, as no prayer for setting aside the appointments has been made by the writ petitioners, or as we find the regularization of the private respondent is without any basis. And as regulation 13(1) of the regulation of 2008 does not provide for regularizing temporary contract employees, the regularization of private respondents are considered to be illegal. The private respondents thus cannot be made senior to the writ petitioner, and the seniority, if any, in the post of LD will have to be counted from the date after 18/5/2011. In view of this reason, we find no any reason to interfere with the judgment of a single judge. Lordship, may kindly appreciate the fact that when the petition was filed, everyone is already promoted as UDA.
We'll continue.
Lordship. The Union of India experienced some difficulties in giving effect to the direction of this court, as it found that if regularization was granted with effect from the date of the initial appointment, all the ad hoc appointees, several regularly appointed doctors may be relegated to secondary position in view of the earlier appointment of ad hoc, doctors. The regularized doctors therefore filed application before this court for giving effect to the order. Then Lordship may kindly read from paragraph 9 to 11. The court's order dated 4/9/487 and 29/10/91 make it clear that this court did not intend any regularized doctor to steal a march over the regularly appointed doctors, either individually or as a group, to ensure that the seniority and promotional prospect of regularly recruited doctors were not affected. This court directed a separate seniority list in respect of the regularized doctors and clarified that their promotion will only be in supernumerary posts to be created. Supernumerary posts are non-gathered permanent posts. They are graded to accommodate the dean of officers who are entitled to hold a lane against regular permanent posts. Being ex-cadet posts, no specific duties were attached to them, and the officers concerned usually perform duties in some vacant temporary permanent post. If all the ad hoc doctors were to be regularized with effect from the date of the initial appointments, with seniority also from the date of the initial appointments, there will be no difference between regular recruitment and regularization of ad hoc appointments, thereby defeating the very purpose of systematic regular recruitment through UPSC. All ad hoc stopgap appointees were not normally regularized and given seniority from the date of initial appointment. They were usually given regularization and seniority only after a certain period of service, which used to vary from 1 year to 10 years or even more. When this court directed on 8/9/497, the regularized doctors will have seniority from the date of their initial appointment. It was only a direction intended to regulate the seniority intercede the regularized doctors, as this court found that among the ad hoc appointees, regularization was not being effected in accordance with seniority, and some who were subsequently appointed were regularized earlier, and some who were earlier appointed were being regularized later. It was not intended to affect the seniority of regularly appointed doctors. The regularized doctors cannot occupy the post meant for regular. The regularized doctors cannot occupy the post meant for regular doctors, either at entry level or at higher promotional levels. Either at entry level or higher promotional levels. That may kindly be taken into consideration. Now, Lordship, on the issue of delay. Firstly, Lordship, Rashmi Rekha Majumdar, Lordship has given a photocopy of the judgment. It should be there.
Rashmi, W8
Yes. Lordship may kindly refer to paragraph 24. Very Lordship.
24. Yes.
We are of the view that non-adherence to the relevant rules and guidelines goes to the very root of the matter, where the technical consideration of non-jointer of parties and non-challenging of the TPC minus, as well as delay in filing the writ petition, should pave the way to the consideration on marriage, which we have dealt with here in above. More so, the cause of delay in challenging the promotion of the previous respondents in the year 2009 has been explained by the appellants as it was only when promotions were made in the year 2014, the appellants became aware of being superseded, and therefore the writ petition was filed as when they found themselves aggrieved by the promotion of the previous respondents. Thus, we are of the view that dismissal of the writ petitions and above technical ground is not warranted in the facts and circumstances of the present case. Lordship, in this case, on the ground of delay, the petition was dismissed. If my lord kindly recollects, in Joyson, Western State of Nagaland, that NITC case, which Lordship has delivered. In that, the long delay, Lordship has condoned since the challenge that the appointment of previous respondents was violation of the rule, like the similarly case. In that case, this honorable court, the Lordship has condoned the delay relying on these paragraphs of this judgment.
Yes, yes.
Now, Lordship may kindly allow me to make a small submission here. Subject to repetition. Lordship in Monya Toipatia. In spite of the long delay, in view of the long delay in filing the petition, the learned single division bench modified the judgment of the learned single judge, saying that in view of the delay, they will not be terminated from service, but you will be in the bottom of the seniority list in view of the fact that the appellant petitioners approached the court late. Now here, Lordship, in paragraph 24, the learned division bench of this honorable court has gone a step further and coming to a finding that when non-adherence to the rule, the non-adherence to the rule goes to the very root of the matter. So the technicality like delay should not come in the way of justice. So, my lord,
Here, court also said that they did not know about the supersession.
yes, my lord, if Lordship may
They
kindly,
became aware only in
my lord,
2017.
Lordship may kindly say that if the paragraph 7 and 8, which I have read in the morning, Lordship may kindly take note of the fact, and Lordship also may kindly appreciate the fact promotion is made in the year on 1st June 2026.
Okay, promotion was made, but the seniority list
Of 2018.
2018.
2000, so my submission here, that is why my submission is that, Lordship. That's why, my lord, I'm relying on these two judgments. First, subject to repetition, Lordship, in Monya Topaitea, there was a long delay. And in that view of the matter, the honorable court says the petitioners had challenged the regularization order before a single judge. The division bench gave a concession by waiving that and said that, yes, since there's a violation of rule, you regularized the horse rules, but since you approached the court late in the fact that you have served for a long period of time, let them remain in the service, but put them on the seniority list. Delay was a consideration, Lordship. I have just read the relevant paragraphs and gone a step further, my lord. I have already explained under what circumstances we approach, because Lordship may kindly appreciate the fact 2018 is a tentative seniority list only. No final seniority list has been issued till date. Though they say the claim, they are saying that it is we treat it as final, no final seniority list has been issued. 2018, Lordship may kindly appreciate the fact 2011 seniority list, 2016 seniority list, in view of the discrepancies, it was redundant. 2018, it was tentative seniority list only, Lordship. Now, Lordship, another judgment. 2008, 8 SEC 648.
Yes. There's
Yes, Tarsi.
Simpson.
My lord, I am good. Lordship, kindly allow me to read paragraph 7. My lord, the facts of the case. My lord, kindly allow me to read paragraph 4 first. May I read, Lordship? The principles of underlying continuing wrongs and recurring successive wrongs have been applied to service law disputes. A continuing wrong refers to a single wrongful act which causes a continuing injury. Recurring successive wrongs are those which occur periodically, each wrong giving rise to distinct and separate causes of action. Then Lordship, allow me to read the quoted portion. It is the very essence of continuing wrong that is an act which creates a continuing source of injury and renders the doer of the act responsible and liable for the continuance of the said injury. If the wrongful act causes an injury which is complete, there is no continuing wrong, even though damage resulting from the act may continue. If, however, a wrongful act is of such a character that injury caused by it itself continues, then the act constitutes a continuing wrong. In this condition, it is necessary to a distinction between injury caused by the wrongful act and which may be described as the effect of the said injury. Then Lordship, paragraph 7. To summarize normally, a belated service-related claim will be rejected on ground of delay in laches, where remedy is sought by filing a writ petition, or limitation where remedy is sought by application to the administrative tribunal. One of the exceptions to the said rule in these cases relating to continuing wrong, where a service-related claims based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy with reference to the date on which the continuing wrong commenced. If such continuing wrongs creates a continuing source of injury, but there is an exception to the exception. If the grievance in respect of any of the administrative order which related to or affected several others also, and if the reopening of the issue would affect settled rights of third parties, then claim will not be entertained. So, my lord, in my writ petition, that is why, my lord, I've shown you the relevant paragraphs in my writ petition. My lord, here, it's a clear case of continuous wrong. That is my specific evidence in the writ petition, which I have shown your lordship. The private respondents.
Yes.
Were initially appointed through backdoor from the period subject to repetition from the period 19/6/2000 to 28/8/2003.
Yes.
Then thereafter, lordship, the horse rule you were regularized by the cabinet. And in view of the fact that you were regularized the horse rules, you were, my lord, included in the service rule of 2016-2018 above us. The very inclusion of them in their cadre, in the regular cadre, lordship, we are aggrieved. Because you was not enjoying all the facilities of being declared considered as a senior above us. And thereafter, lordship, in the year 2016, now they are promoted to the regular cadre of vice principal, which is supposed to be occupied by those who are appointed in accordance with the rules. So it's a continuous course of action, continuous wrong from the date of the initial appointment till now. And lordship, we kindly appreciate the fact that, as I said initially in the morning, there is no third party interest has been created. The seniority law clearly shows that it is between us only. Immediately we are below them. So, my lord, my respectful submission is that the principle of continuous wrong as decided in the Tarsim Singh applies in the present case to condone the delay, if at all delay has to be considered. So, my lord, summing up my submissions. This is a judgment, lordship. And summing up my submission, lordship, I need not speak much. Lordship, you appointed the horse the rules, and my lord, I have satisfied your lordship with the relevant judgment of the Honorable Supreme Court that the word employment or appointment covers not only initial appointment, but also all the other attributes of service like promotion till retirement. Now, now you are appointed illegally and you continue to enjoy and you form a separate class. So my respectful submission is, yes, had we approach immediately, then it would have been a fit case where the appointment of the private respondent would have been terminated, would have been quashed and set aside. But in view of the fact that they have served for a long period of time, and the judgment of the dishonorable court in Munya Topaitia and other cases which we have referred to, lordship, I have no objection if they are allowed to continue in service, but
They should be pleased.
they should be in the bottom of the seniority list. And in that view of the matter, the promotions granted to some of the private respondents to the post of vice principal should be quashed and set aside also as a consequence, and they should be kept in the bottom of the seniority list, and a direction should be given to the official respondents to consider the case of the petitioners for promotion to the post of vice principal on the vacancies presently occupied by some of the private respondents in the present case.
Okay.
Much obliged, lordship.
Yes.
May I please, Your Lordship?
Mm.
I have requested Mr. N. Ankami to submit first,
Mm.
since they are the state respondents. But he, at the same time, he's insisting me to submit first. So
It's okay. Doesn't
I'm
make a
grateful to
difference.
him,
Both of
and,
you will have the same ground.
yes, I think
Yes.
we may have to have 3 replies today. In an unusual manner, the counsel for the petitioner has started his submission from a reply by referring to an additional affidavit which has been filed subsequent to the filing of the writ petition. Because, and thereafter, after finishing that, he has referred to our affidavit and the summary of the points which we have taken. And to cover up that, he wanted to make submission on those points. Now that I'm submitting my case, and N. Ankami will submit thereafter, again, the petitioner may like to make replies as a matter of right. But then it will be a repetition. And I was expecting that the petitioner will start his case. What is his right? And how his right has been violated? What legal right of the petitioner has been violated? I was expecting that the argument will start from there, because first thing first, a person who is approaching this honorable court under Article 226 must have a legal right, and that right has been taken away without any authority of law. And the petitioner should be able to establish a prima facie case in his favor. Then only they can come. Along with filing up the writ petition, Lordship is well aware, Lordship has got wide experience of the proceeding of the High Court. There are so many criteria while filing the writ petition, it should be fulfilled. For instance, whether there is a right, whether there is delay in riches, whether the petitioner has approached the honorable court with a clean hand and heart, and then whether the writ petitioners will have the locus standi or not. All these principles are to be taken into consideration by this honorable court. And on all these principles, the law has been laid down by the Apex Court, this honorable court as well as the honorable Apex Court. First, those criteria has to be fulfilled. Thereafter, the petitioner will submit. The petitioner will be maintainable. Then only the petition will proceed. This is a case where the petition appears to be a frivolous writ petition. First, Lordship may kindly see the prayers made in the writ petition. There are as many as 18 prayers. Lordship will find at page, from page 55 to 61. There is a convoy of prayers, like an army convoy, 18 prayers. And if your Lordship look at the prayer, what are the prayers? It
No, but
starts
they have considered that he is not challenging the appointment orders.
appointment orders.
Appointment orders.
If
Only
that
the
is the case,
seniority. Finally, it is only the seniority.
yes,
Hmm.
seniority, okay. Then in that case, now that this is a case, it's not that they have filed and then moved without any opposition. There was a caveat we have filed before filing the writ petition.
It is.
There was a caveat, and then on the day of motion, we were heard.
Hmm.
That must be the possible reason why the interim order was not passed by this honorable court. And during the motion, we have made a categorical submission on the imbued order, that is the seniority list of 2018, where the writ petitioner has not enclosed the covering letter of the memorandum, that is the seniority list, whereby claims and objections on the seniority list was invited and to submit within a period of 30 days. And if no representations or complaint is received within a period of 30 days, then it shall be treated as final. That was in 2018. I'm not referring to the date since my learned friend has already referred to the date. When we have pointed out this, because it is part by limitation again. Once you fail to exercise your right within the stipulated time, you forfeit your right to raise objection against this. And knowing fully well, they have enclosed in the writ petition all the minutes of the committee, minutes of cabinet, all this. They are capable of obtaining all these informations, but the covering letter in the seniority list, tentative seniority list,
That was not.
was not enclosed. So we pointed out before the Honorable Court, look, it is like this. Then subsequently they file an additional affidavit by enclosing this document. And the argument has been started from this document. Reason is very clear. They have filed a defective writ petition with an ill motive to obtain an interim order from this court on the day of motion. That is the reason why they have not enclosed two vital documents. One, this covering letter of tentative seniority list, where claims and objections have been invited. Second, there was a writ petition filed by the present respondents, WPC number 163 of 2012, where the order was passed dismissing because we claim seniority from the date of notification of the government of 2007. That was not given. Thereafter, writ appeal was filed by us.
Yes.
That was also dismissed, so upheld. Basing on the order and direction passed by this Honorable Court, because the direction of this Honorable Court in that case was the seniority of the private respondents can be counted only from the date when they are regularized in the service. That is 18/1/2011. That is the date where the cabinet has taken the decision. So we also forfeit that. And government has acted on the basis of the direction passed by this Honorable Court in two judgments. Government has acted by fixing the seniority, by complying with the order passed by this Honorable Court.
So that instead of 2007, it was brought to 11.
Yes.
18/1/2011.
Instead of 2007, it is brought to 11, and we accepted that. Now, my learned friend has referred to so many judgments of the Honorable Apex Court on various grounds. My contention is whether in all those cases which has been referred to, there was a direction by the court to fix the seniority from a particular date that has been passed in our case. No, there is nothing of that sort. Therefore, the ratio laid down in those cases cannot be applied in this particular case because the seniority of the private respondents were determined on the basis of an order passed by this Honorable Court. My learned friend has referred to the writ petition of 163, but apparently he has not referred to the writ appeal. Writ appeal is 174, I think, of 2012.
April 17, no.
75. In affidavit in opposition of the private respondent number 5 to 27, I have enclosed. There are only page 27. It is there.
affidavit in opposition on behalf of 5 to 27.
Yes,
Page 27.
20.
Yes.
Kindly
Read
come
the
to
page
again.
75. 75 of
Yes,
2014.
yes. Again, kindly come to paragraph 7 of the writ petition. Here they have mentioned about the order passed by the Honorable Court. Paragraph 7. Let me read from the third line of page 41. Sentence starts with thereafter. Because this,
Thereafter, a notification.
yes, a notification so-and-so was issued by the government reiterating the effective date of regularization of the present private respondents as reviewed by the cabinet on 14/5/2007. The date of regularization of the present private respondents became the subject matter of WPC 163 of K of 2012. Thereafter, by a notification dated 21/3/2014, the state government had constituted a committee for determining the principles of seniority of principals, vice principal, PGTs, in accordance with Rule 17 of the Service Rules of 2007. Thereafter, by a meeting minutes dated 7/4/2014, the committee had decided that in view of the decision of the cabinet committee has no discretion to differ from what the cabinet has decided. Finally, the ambient memorandum dated 5/3/2015 in compliance to the direction of the Honorable Court dated 22/4/2014 was passed in WPC number 163K of 2012. It was decided that the department notification dated 6/8/2012 will not be applicable. Accordingly, the ambient notification dated 11/2/2011 was reviewed, whereby the date of regularization of the private respondents shall be with effect from 18/1/2021. Here, the reason for referring to this paragraph is they have mentioned about WPC number 163K of 2012. They are very much clear about the order passed by this Honorable Court, but then it was also not annexed, nothing close. Therefore, by filing the affidavit in opposition, we have brought it to the notice of this Honorable Court about the order passed by this court. Now, combining both, by not annexing the covering letter of the seniority list, and then by not enclosing the judgment and order dated 22/4/2014, passed in WPC number 163K of 2012, all this shows that without projecting the entire facts of the case, they wanted to obtain an order from this Honorable Court. Therefore, the very motive and object of the petitioners has approached this court without any clean hands. Many vital documents were not placed before this Honorable Court. Thirdly, the writ petitioners, by filing this writ petition, are not seeking a direction from this Honorable Court to appoint them in the post held by us. They are seeking to quash our initial appointment also. So if this kind of prayers are allowed, then whether it will be possible for this Honorable Court to review all the orders who are in the rank of director, joint director, additional director, deputy director.
No. We are not going to go into that because petitioner themselves, they are saying that all this, let them remain in service. Let them be in service, but only the seniority that you should be placed below them.
It is nothing but an afterthought. That is what I'm trying to bring, Lordship. If you want seniority, if you want promotion, you strike on that point. But they are questioning our appointment every now and then. And with that question, they want to bring together and then get the date for counting up their seniority. other than the date when they were appointed. Little background. Why we were appointed?
They were appointed on 21/3/2011. 21/3.
Yes. There is a cap of 39 days. Regularized by notification dated 11/2/2011 with effect from 18/1/2011. And then the petitioners were appointed on 21/3/2011.
2011.
Yes. Now, theory has been brought in by relying on the so many decided judgments that these should be made senior to them. But Lordship is well aware. On the day when we were regularized, they were not in service. And Lordship is well aware. The life of the selection process, it starts with the inviting applications for the post and culminates with the filling up of the vacancy. In their case, when the vacancy was filled up, it was filled up on 21/3/2011. So, a person cannot count seniority in the service before he or she is appointed. Same analogy, another example. My date of birth is a particular date, and my age will count only from the day when I am born. I cannot celebrate my birthday before I'm born also. Therefore, but petitioners are claiming a right. Before they were appointed, they should be given seniority date, another date. What a date should be given? What artificial date should be given by this Honorable Court other than 21/3/2011? And if such a practice is started, then it will lay down a bad precedent. It will amount to opening a Pandora's box, which will be very difficult to control. So, it is nothing but an afterthought and a wild imagination of the petitioners. Therefore, the writ petition is liable to be dismissed. I would like to cite the judgment on that, the life of selections. This is a case of a constitution bench that is headed in 2025 only. Relevant paragraph is paragraph 22 and 65.1. Only 2 lines. The Honorable Supreme Court has said when the selection starts and when it ends. Because they are claiming that, look, we were recommended long before, but there was delay in appointment of the petitioners, and while pending the appointment, the private respondents were regularized. Therefore, they should be excluded and treated as a differentiator. That is what the petitioner is claiming. Yes, this Prakash case. Oh, say this.
Para 22 and 65.1.
Yes. Just 2 lines each. Input the paragraphs.
Yes.
These are all in the form of a preliminary application, Lordships.
Yes. Process of recruitment begins with.
Coming to the issue of seniority, it is settled in terms of WPC number 163 of 2012 and Writ Appeal 75 of 2014. Because seniority has been fixed pursuant to the direction passed in these 2 cases, And the writ petitioners have not challenged these orders also. That is the foundation and basis of fixing the seniority, because we wanted from 2007, High Court rejected, no, your seniority can be counted only from the date of cabinet decision, that is 18/1/2011. Therefore, government has acted on that, implemented. And as such, no other date can be given. That is why I am referring that all the cited cases, in all the cases where there is any direction by the court to fix a particular date for determination of seniority, in our case it is there, but in their case it is not there. So it is irrelevant so far as our case is concerned. Do you want to dig out something from the grave? Government has already implemented, acted way back in 2012-13. They remain silent. Now, by lately approaching this honorable court, they want a direction from this honorable court to issue an unworkable order. How? Do you want an order to be passed by this honorable court, an artificial date, either for us or for them, for counting of seniority? And in order to do that, unless an illegal action is committed by this honorable court, such a relief cannot be given. Such a relief can be unworkable. What type of a relief can be given in this kind of a situation when they were not born even in the cattle? Artificial date should be given. And seniority has been fixed in terms of the order passed by the honorable court. And they have not challenged that. Therefore, Lordship, taking into account of all this, the writ petition is frivolous. Petitioner has failed to make out a prima facie case.
63 was filed by you,
Yes,
asking for 2007,
correct.
and it was dismissed.
Yes,
Then you filed a writ appeal that was also dismissed.
yes,
Then after that, it went back to 18/1/2011.
yes,
Your seniority.
yes, 18/1/2011.
And this seniority list of 2011 and another one, the
16, I think.
16.
16,
So
2016.
they were never assailed, isn't it?
Yes,
They were never challenged.
they have not.
This is the
Let
this is
us-
the first repetition.
Yes,
This is subsequent to the judgments.
the latest seniority list was in 2018,
2018.
and they have challenged it in 2025. The met submission that they have been submitting representation, I'll cite some rolling on that constitution bench judgment. So that is on the ground of preliminary. So even without entering into the merit of the case, it is a fit case where it has to be dismissed on the ground of maintainability. On the preliminary issues, this case deserves to be dismissed, because the writ petitioner has failed to make out a prima facie case. There is delay in lectures. They have not approached this honorable court with clean hands, and no locus standi also. No locus standi to question our appointment. Now I will come to the merit. The background, how we were appointed, because I'm coming to the merit. Sometime in early 2000, there was high public demand for upgradation of high school to higher secondary. And Nagas are so popular and so expert in this kind of a practices that if a particular action is taken, like them, we should also do. In their tribe, it was done. In their district, it was done. In our district, it should be done, all this. So there was a wave of upgradation of so many high schools to that of higher secondary. Government was at the receiving end. So government, of course, therefore the government, a public. So they thought it appropriate to upgrade the higher secondary. So many schools. So what happened? Since it is upgraded, classrooms have to be 11 class, 12 class are to be there. It has to be taught by qualified person. But since it is already upgraded in the midst of the academic session, classes has to run by way of an advertisement, proper advertisement. It will take a year or two. We never know when it will be completed. But classes has to run. Therefore, in view of all these problems, unless appointments are made on contract or ad hoc, it was not possible to teach the students because government will be depriving the students and it will be at the cost of the students if no appointment is made. Therefore, it was thought it appropriate to appoint the petitioners. There are many on contract and ad hoc basis. Some are appointed after selection also, like that. 2002, 2003. During these 3 years, they were appointed. Some are a little early, some are a little late, but 2002, 2003. During this period, my dear Omar Devi was also not there. Omar Devi came on 10th of April 2006 only. So our initial appointment was made before Omar Devi was trimmed up. And at that relevant point of time, all were eligible, possessing requisite qualification. All appointments on a talk or contract were met against regular sanction post. And the fact remains that they continued to serve regularly without any interruption in the service. During this period, Lordship, 2000 to 2003, when we were appointed and we were teaching, some of the writ petitioners were our students because they were in the school, high schools, most of them. They were our students. In view of the long uninterrupted and dedicated services, government thought it appropriate to regularize our case on the strength of the 2007 office memorandum. Since my learned friend has already referred to the OM 23/2007, I'm not referring to that. So by conducting a suitability test, all the private respondents were appointed by way of a policy decision of the government on the basis of the laid down policy. And they were regularized on 11/2/2011 with effect from 18. So to regularize or not, it was the prerogative of the government. So government thought it appropriate to regularize our services. That was in 2011. Now, this regularization order is based on 23/8/2007 policy. That is the basis of our regularization, and the basic order has not been challenged by the writ petitioners also. Although our regularization order has been challenged, but on the basis of which our regularization was made, the basic order of 23/8/2007 was not challenged. Therefore, even on that count also, the writ petition fails and is liable to be dismissed. As I was mentioning, the seniority list was circulated in all departments under the government. When a tentative seniority list is circulated, it is circulated among all the employees, inviting claims and objections. But then they have not enclosed that. Their contention is due to inadvertence. So that was after we pointed out during the motion. they have filed additional affidavit and brought on record. Now, kindly come to page 29 of my affidavit. Affidavit in opposition of respondent number 5 to 27. Page 29, annexure F. Thereafter, I will come to page 182, but then first, page 29 of our affidavit. Mr. Lordship, correct? May I read this? This is 11 May 2018 memorandum. Tentative seniority list of officers of government higher secondary schools under the school education. Page 29, annexure F. F. May I just read the body of the letter? A tentative seniority list of officers of government higher secondary schools under the school education department as on 11/5/2018 is hereby circulated, published for information of all concerned as per the list enclosed. The list has been prepared after examining all relevant documents available with the department. Any objection, claim, complaint against entries in the list should be submitted through a representation supported by the documentary proof within 1 month from the date of issue of this memorandum. If no representation is received within the stipulated time, this seniority list will be treated as final. So this has not been enclosed along with the seniority list which they have enclosed in page 182 of the lead petition. 182. They enclosed the minutes of the committee, but this vital document of memorandum 11/5/2018 has not been enclosed. So it is not only delay in lectures, limitation for claiming the right has also been extinguished and forfeited by the petitioner themselves.
Yes.
I will just conclude. There is some subsequent development. On 9/4/2026, the private respondents were promoted to the post of vice principal. Not all, some of the respondents. And here, if Lordship look at the factual aspects, one of the petitioners will retire in 2031, one in 2032, one in 2033. By 2036, all the respondents will retire from service because they joined in 2000 and 2000, between 2000 and 2003. All the petitioners, they have to go a long way, and many of them will retire by 2045. They have a long prospect to go. And if they are aware about their rights as they are claiming now, what prevented them to question and challenge our appointment in 2012, 2013, 2014, and so on? So also, what prevented them to challenge the seniority list of 2018, the last seniority list which they have challenged, only in 2024? Therefore, the writ petition is hopelessly barred by
2025.
Yes, 2025. Hopelessly barred by delay in lectures, hit by delay in lectures. And as I was submitting towards the beginning of my submission, my learned friend was made big trust on the root of the matter. But slowly and slowly, towards the end of his argument, he considered with the challenge to the appointments. Otherwise,
Seniority.
no, he confined to the seniority, he abandoned the claim for challenging the
Appointment.
initial appointment. Maybe they may have realized that if I challenge the appointment also, then everything will go at the time. So let me forego this and then I will confine only to the seniority. Even for that also, law is very clear. Law is for the diligent, not for the sleepy. Lordship is really aware what they have been doing for the last 7 years to challenge a seniority list in the same department, which was circulated to all the employees. Therefore, the writ petition is nothing but an afterthought. He woke up from the slumber and then, if I claim this, if I try this, I may be senior to the private respondents. So even the conduct of the petitioners is not a claim. Any person approaching this honorable court should approach with a clean hand and heart, Lordship. Therefore, the writ petition is liable to be dismissed. I would like to refer to only few judgments. I will not take much time to read. Only the relevant portion, few judgments I can read.
On delay or on what? On the point of delay.
On the seniority mostly,
Seniority.
and the delay in lectures. 1998 2 ACC 523. That is on the point of seniority should not be reopened after a lapse of reasonable time. Okay. Paragraph 7, 1998 2 ACC 523, para 7. And next, on delay in lectures, 2011, 5 SCC 607, para 46, 50 to 54, and 136. The third one I would like to read.
This is on delay.
This is on delay in lectures.
Yes.
607. Here. Third,
Yes.
1997, this is a constitution bench on the ground of inordinate delay and no explanation even if you submit a representation. So this judgment, I would like to read out few lines. I will read only 4 lines. 1977, 3 CC 396. This is a constitution bench, para 6. Relevant portion, 4th line from the top, 5th line. There is no satisfactory explanation of the inordinate delay for, as has been held by this court in Rabindranath Bose versus Union of India, the making up repeated representations after the rejection of one representation could not be held to be a satisfactory explanation of the delay. So, although they have enclosed only one representation in the writ petition, during the course of submission, my learned friend has made a submission that they have made several representations. Even if you have submitted that, that is not the justification to overcome the delay. So, the petitioner has been sleeping over their rights, and that 2011, 4 ACC 374, paragraph 27 and 28. Next, on the same point of delay in leches. 2010, 12 SCC 471. Paragraph 18 to 30. That is on the point of delay and leches. And my learned friend has referred to C.N. Moore case, where I was also one of the counsels in that case. The effects in that case is slightly different because the number of days between the regularization and appointment was also different, and there was no delay in approaching the honorable court also. So in most of the cases, there was no delay. The most of the cases which my learned friend has referred to, in all those cases, the petitioners have approached the honorable court on time. So it was found to be a fit case for indifference by this honorable court. But here is a case. In our case, there is unexplained and inordinate delay in filing the writ petition and challenging the seniority as well as the regularization order. Regularization order is up 2011. They are challenging in 25.
Yes.
And at best, our appointment can be treated as an irregular appointment in the light of the paragraph 53 of the Omar DB's case. And as I have submitted during our appointment, Omar DB case judgment was not there. So in the late of the day, somebody has just woken up from the slumber and coming, and then Omar DB's case has laid down a law, and then all the appointments should be open and set aside in question. To consider all these points, as I was mentioning, whether the petitioner has established a prima facie case, whether the petitioner has approached this honorable court with a clean hand, whether there is delay in leches, whether there is locus standi or not, all this has to be considered first. And only when they satisfy all these points, and all these points are the law laid down by the apex court. Therefore, those points should not be ignored also. They did not have the locus standi even the question of regularization on 18 of January. For that matter, 11 to 2011 also, they did not have the locus standi. And coming to 18/1/2011 also, they do not have the locus standi because their appointment is only 21/3/2011 after 39 days of our regularization. Therefore, the petition do not have any merit, therefore liable to be dismissed with cause. Obliged, Lord.
May I please, my lord?
Yes.
Lordship, while endorsing the submission made by my senior counsel, your lordship, since the petitioners is not pressing for against the appointment made or given to the petitioner by the state government, your lordship, and therefore I will not make much submissions on that. I'll straight away take my lordships to as to how the seniority position has to be determined, your lordship. And for that, your lordship, I want to my lordship to come to page 14 of my affidavit in opposition.
Yes.
Page 14, your lordship. The case of the petitioner was placed before the cabinet for regularization, your lordship.
It should be. Page 14 and extra B.
Yes, my lord. And
Yes.
the cabinet has given its approval for regularizing the
contract ad hoc service of the petitioner through this office memorandum dated 20 January 2011, my lord. I wanted to read out the body, the body as to how the cabinet gave its approval, Your Lordship. That starts with the cabinet approved. I may be allowed to read this, my lord.
Yes.
The cabinet approved the proposal for regularizations of the contract service of 25 postgraduate subject teachers under higher secondary schools with effect from the date of cabinet decisions. However, their contract service will count towards pension, leave, etc., but not for seniority. So the seniority will start counting from the date the cabinet gave its approval, Your Lordship. Now, basing on this office memorandum, my lord, a notification dated 11th of February 2011 was brought out, which Your Lordship will find it at page 93 of the writ petition, my lord.
Yes.
Now, by these notifications, Your Lordship, the 25 contract ad hoc teachers were given regularization with conditions, Your Lordship. And the conditions, Your Lordship will find it below the names. Below the names, Your Lordship.
Yes.
Condition 2. Condition 3, Your Lordship, in fact. Conditions 3, I may be allowed to read this, Your Lordship. The period of service rendered on contract basis prior to 18/1/2011 will count for all other purposes such as pension, leave, etc., but not for seniority. Now, why 18/1, Your Lordship? 18/1 is the date that the cabinet gave its approval. And the memorandum was brought out on 21/2011, but the cabinet gave its approval on 18/1/2011. And therefore, the notifications clearly says that for all other purposes except for seniority, the date should be counted from 18/1/2011, my lord. Now, Your Lordship, when the notification states that the seniority has to be counted from 18/1/2011, nobody has got any grievances, Lordship, to these notifications. But when the government redecided that the effective date of regularization and seniority has to be counted from 14/5/2007, some of the postgraduate teachers who were appointed through MPAC in 2008 were aggrieved, Your Lordship. And therefore, they filed.
batch.
Yes, 2008 batch, who were recruited through MPAC, Your Lordship. They were aggrieved by that decision of the government, giving retrospective effect
From 2007.
from 2007, Your Lordship. And therefore, this batch of 2008 filed a writ petition, which is WPC 163 of 2012, my lord. Challenging the decision of the government, giving retrospective effect to this contract and ad hoc employees from 2007, my lord. Now, this was disposed of, as my lord has already seen. This was disposed of by an order dated 22/4/2014. I have annexed it at page 16 of my affidavit in opposition, my lord.
Page 50.
Affidavit in opposition, your lordship, for respondent number 1 to 4, my lord.
Yes,
Yes, your lordship.
22-4.
22-4, your lordship. Now, this writ petition, WPC 163 of 2012, was allowed by this honorable court. Was allowed by this honorable court. And I want to take my lordship to as to how this honorable court allowed this particular writ petition, your lordship, to the basis as to how this honorable court has allowed this writ petition, my lord. My lord, may kindly come to page, the type copy starts from page 21, my lord.
Yes.
My lord, may kindly come to page 22, the last para. The last para. If I may be allowed to read this, my lord. In that connection, it has been stated that regularizations of contract, ad hoc, contingency employees is governed by certain sets of guidelines and office memorandum. It may be stated that way back in 1975, the state respondent issues guidelines stating that the date from which the seniority, etc., of the employees who works on contingency, ad hoc, contracts, and who were regularized later is to be counted. For ready references, the memorandum dated 8/5/87 to 1975 at Annexure D of the writ petition is reproduced here below. So the state government has brought out the policy as to how the seniority of the person who has been regularized subsequently is to be counted, your lordship. And on the office memorandum, your lordship, if you see at the end part of the office memorandum dated 8 July 1975, lordship will find that starting from but seniority in a particular cadre should count only from the date of regular appointment and should follow the order of merit given by Nagaland Public Service Commission or the selection board. So it should start counting from the date they received the regularization order. Here is a case where the date of regularization actually was given on 18/1/2011. Retrospectively, again, decided to give it from 2007. That is why they are here before this court, your lordship, by filing this particular writ petition, your lordship. Now, your lordship, the next para, if I may be allowed to read this again, it again says, this preposition, that is the preposition initiated there in the office memorandum, has been reiterated again and again by the state respondent issuing the office memorandum 9/11/1975 as well as office memorandum 9/7/2004. The above memorandum makes it more clear that a contract, ad hoc, contingent employees can claim seniority in service from the date on which his service was regularized and not a day before. The aforesaid prepositions of law has been reiterated by a court no lesser than the apex court of the country in the case of Sanjay Kesha and others versus State of Bihar and others reported in such and such, my lord. Then coming to page 24, my lord. I wanted to read the second and the third para, your lordship. The second para, starting with coming to our case, your lordship. I may be allowed to read this. Coming to our case, I have found that the private respondent worked on a contract basis till 17/1/2011. They were regularized for the first time only on 18/1/2011. This only demonstrates that the private respondent can claim seniority in the grade of postgraduate subject only from 18/1/2011. Therefore, the notifications dated 10/2/2011, which clearly specifies that the private respondent can claim seniority with effect from 18/1/2011, is found to be perfectly in tune with the law laid down on such point. The next para, my lord. In the instant case, there is no dispute over the facts that the petitioner joined their service as postgraduate subject teachers on being recruited in accordance with the recruitment rules. There is no dispute over the fact that the private respondents were appointed on contract basis and such appointment commenced from 2000 and the same continued for several years. There is also no quarrel over the fact that the service of the private respondents were regularized at first with effect from 18/1/2011 by notifications dated 10/2/2011 on the recommendation of the cabinet. Your lordship, the next line is important. Being so, For all practical purposes, the private respondent born in the grade of postgraduate subject teachers with effect from 18/1/2011. So the seniority position as to from which date it has to be calculated has already been decided by this honorable court. And therefore, your lordship, and therefore, since the date from which the service of the seniority has to be counted, according to this honorable court, should be from 18/1/2011, and therefore, the notifications given effect, the seniority from 2007 is squashed and set aside, my lord.
Yes.
Now, your lordship, the private respondent in this particular writ petitions has filed an appeal before the division bench, which was subsequently dismissed again, your lordship. So this order stands as of today, my lord. Now, from this order, your lordship, quashing and setting aside of the notifications which says that the private respondent's regularization should take effect from 2007. If that is quashed, what remain, your lordship? What remain is the office memorandum where the private responding is regularized on 18/1/2011. Your lordship, there is no ambiguity in this, my lord.
Yes.
Now, your lordship, since they are challenging the tentative seniority list of 2016, your lordship, I wanted to take my lordship to page 152 of the writ.
Even if
152, lordship of the writ. Before I point out the serial numbers of the private respondents and the petitioner hearing in this list, your lordship, I wanted to make one more submission in this, your lordship. Now that it is clear that the seniority of the private respondent has to be calculated from 18/1/2011. Anything that is being done not in conformity with this date will become illegal, your lordship. That is the seniority list. Anything that is not done in consonance with this date, your lordship, will now become illegal, your lordship. And therefore, when the seniority list was prepared, your lordship, I want my lord to come to serial number 140 on page 152. This is serial number 140 is from where the private respondents, the name of the private respondent starts, my lord. And your lordship, moving towards 7th column on the right, my lord.
Yes.
On the 7th column on the right, this is the column where effective date of seniority is mentioned. Effective date of seniority is mentioned. on the seventh column, my lord.
Yes, service regularization.
Yes,
By such and such.
yes. Now your lordship will see that 18/1/2011 effective date as per cabinet decisions and honorable court order dated 22/4/2014. So the department, your lordship, the department has brought out these tentatives, that this seniority list as per the direction given by the honorable court, my lord. Now, following the direction of the honorable court cannot be termed to be illegal, my lord.
Yes.
Now, your lordship, coming to the seniority list of 2018, which is again impugned, the lordship. Your lordship will find the name of the private respondents starts from serial number 134, page 196.
Yes.
Again, your lordship, seventh column towards the right. Again, effective date 18/1/2011. Now, your lordship, effective date, the seniority position, the seniority positions of the private respondent in the seniority list is exactly as per the direction passed by this honorable court. Now, interfering with this, my lord.
And where does the petitioner start?
The name of the petitioners, your lordship, will start from on the next page, 158. 158. Yes. I'll come back to that, your lordship.
Yes.
Now, my lord, this is exactly as per what the direction has been given by the honorable court, my lord. Now, in any case, your lordship, in any case, if this date cannot be changed, and if the petitioner are aggrieved on the ground that the effective date of their seniority is not as per the date that they were appointed, your lordship, they may have a ground. They may have a ground, your lordship. So in that case, for that matter, your lordship, I want to take my lordship to page 68 of the read, my lord. Page 68 of the read. Now, your lordship, this is a notification dated to the 1st of March 2011, and by which, your lordship, the petitioners were appointed on the recommendations of the Nagaland Public Service Commission, man. So the date which they were born into the cadets, your lordship,
Is 21.
is 21/3/2011. Now, has the state government made any changes to this particular date in the seniority list? Your lordship, I want to take my lordship to page back to the seniority list of 2016, my lord.
Yes, we've seen. It is
Yes.
given as 21/3.
Yes.
2011.
So no changes made, your lordship. This is exactly on the date they were appointed. That is 21/3/2011, and the serial number of the private respondent were placed in the seniority list as per the date They were given regularization and also as per the direction passed by this honorable court, madam. And therefore now challenging this or seeking an alterations or changing will amount to illegality, my lord. Because this has been done as per the direction passed by this honorable court. Therefore, no infirmity or illegality has been committed as far as preparations of the lease of 2016 or 2018 is concerned, my lord, by the state government. Another point, Your Lordship, I wanted to raise before this honorable court is this, Your Lordship. The petitioner, the private respondent were already regularized in service. Now that they are not challenging the appointment order. The private respondent were already regularized from their service even before the petitioner were born into the cadres. So that in that case, Your Lordship, will the petitioner have a local standard to challenge then the regularization order, or for that matter, the appointment order of the private respondent? Though, of course, now they have make a submission that they are not pressing for the appointment of the, yes. Still then, Your Lordship, since now they are challenging still challenging the regularization of the private respondent, the regularization was made on the basis of a cabinet decisions and also on the basis of the direction passed by this honorable court. If at all they were aggrieved, they should have challenged the direction passed there in the writ petition, the blue 163. Without making any challenge, Your Lordship, to the direction passed by this honorable court, Your Lordship. Any action taken by the state government in compliance, Your Lordship, to the direction passed by this honorable court cannot be said to be illegal or cannot be said to be wrong, my lord, until and unless that particular order of this honorable court is modified or altered or changed, Your Lordship. Till date, there is no modifications, altered or changed, Your Lordship. And therefore, Your Lordship, the petitioner has got no local standard whatsoever to challenge the seniority lease 2016 or 18 as it is prepared as per the direction of this honorable court and as per the policy decision taken by the state government, Your Lordship. I raise my submission, my lord.
Just one point before my learned friend reply. 2 points, rather. Of course, to some extent, my learned friend has narrated pattern as on the similar line, but this will be the right usage. The seniority of the private respondents were fixed pursuant to a court order passed in WPC 163 of 2012, pursuant to the judgment of 22/4/2024. Any interference in the seniority list would amount to interfering with the order passed by this honorable court in WPC 163 and also the writ appeal. That is one. And to supplement that in there, the petitioners are indirectly, since they have not challenged, they are indirectly trying to do something in contravention of the order passed by this honorable court, because seniority was fixed in terms of the judgment passed by this honorable court. So any indifference will amount to interfering with the judgment. That is one. Second aspect, during the course of argument, the challenge to the initial appointment has been given up. On the day of motion, there was an interim order. Any promotion during the pendency of the writ petition shall be subject to the final outcome of the case. That order was passed when the prayer of the writ petitioner were composite, including the initial appointment order. Once they succeed in challenge to the initial appointment, automatically regularization will go, subsequent promotion, everything will go, along with the writ petition. So that will be perfectly okay. But now that they have given up the challenge to the initial appointment order, and there is a subsequent development during the pendency of the writ petition, that is the promotion of the private respondents on 9/4/2026. Then it will not be automatic in the writ petition to examine this fresh course of action without any proper pleading with regard to the subsequent action. By filing an additional affidavit, they wanted to rope in this, that any pleading that has been taken in the writ petition may be connected with this. But then in this writ petition, we did not get any opportunity after we accrued the right pursuant to the order passed on 9/4/2026. And if it is to be interfered with, then in that case, without affording proper opportunity of being heard, the order has been passed. Therefore, the interim order will not cover if they forego with the prayer of the initial appointment. That is what I wanted to put it before the honorable court.
May I please,
Yes,
Lordship?
yes.
Lordship, I will not take much time, but kindly allow me to make some pointed
Yes.
replies.
Just
I will not
take
take.
it in about 10 minutes.
Yeah, less than that. Number one, Lordship, on the issue of maintainability, much has been raised. My Lord, and then on the question of maintainability in locus standi. Lordship, you were appointed, divorce the rules. That's how petition is maintainable. And my rights has been agreed, and that's how, Lordship, I have locus standing to challenge. Since you are appointed, divorce the rules, and the locus arises when you were wrongly included above us in the seniority list. Secondly, Lordship, that Prakash judgment was relied upon. My Lord, that Prakash judgment, if my Lord, can you read the judgment? It is about changing the rule of the game after the match started. Here, in that particular case, my Lord, the judicial recruitment case, my Lord, the marks for viva voice was changed after the interview was concluded by the High Court. That is the case from Rajasthan. So that is where, my Lord, this will not be applicable. Now, my Lord, on the issue of that, an issue was raised that basic order has not been challenged. That is that I have not challenged the 2007 and 2008 office memorandums by which you were regularized. So basic order is not challenged. Lordship, I have shown in the judgment of 145 and 18, 18 of PD28 that this Honorable Court has declared it to be violative of 14 and 16 and declared already.
That was the 2008 memorandum.
My Lord, if Lordship may kindly see, the 2008 has modified the 2007 memorandum, which is
Action
the
which
first
has been
practice.
already taken
My
under
Lord,
2007.
It is so I was making a
that's-
submission there that you were regularized in the year 2011. So, my Lord, when you were regularized in the year 2011, 2000 notification, which has modified 2007 office memorandum was holding the field. So I was making a submission that it was a wrong statement given by the government. Because in 2011, 2008 was holding the field. And that was declared to be illegal already. Secondly, Lordship, the judgments of 1998 that seniority cannot be opened after a lapse of time. That was the judgment relied upon by learned friend, and then the representation on delays judgment has been relied. My Lord, in these issues, the seniority from 1998 judgment on which my learned friend has relied upon, is about seniority amongst people who are recruited in accordance with rules. Here, I'm appointed recruited in accordance with rules, you were regularized backdoor. So those judgments will not apply. Secondly, Lordship, upon my representation, my Lord, about my representations, my learned friend has made a submission. The submission of representation has not been enough. My Lord, I'm making a categorical statement in my petition that my representation is yet to be considered and disposed of till date. It is still pending. My Lord, in that view of the, and then my Lord, my learned friend has made a submission that you will regularize in terms of 3 years of his memorandum. So at the most, your appointment is irregular in nature, not illegal. But to that aspect, Lordship, I am praising the judgment of Madan Singh versus State of Haryana, where the 3 years regularization in State of Haryana, the scheme was declared illegal by the and struck down. Now, my Lord, the government advocate as well the state government, my learned friend, senior friend, has made a strong reliance that seniority dated 18/1/2011-21 was in terms of the cabinet decision and the direction of this honorable court. And that cannot be changed. My Lord, Lordship, I have challenged that all these notifications. I made a categorical statement and challenge on the ground that the cabinet decision is in violation of the service rule. Now, my Lord, starting from Rafa Kitik and the 3 division bench judgments which I have relied upon, and finally, Lordship, the judgment of this honorable court in my Lord, PPC Ravani versus Unit of India. In all these cases, what this honorable court has consistently decided is that the date of regularization is not an issue. In which state I'm regularized, which state he is regularized is not an issue. The issue before this honorable, the issue is whether you were regularized in accordance with rules, whether I am regularized in accordance with rules. Accordingly, over the series of judgments, this honorable court, the division bench, 3 division benches of this honorable court in the Honorable Supreme Court has held that even if the people who were illegally regularized were regularized earlier than me, and I am appointed later to them, after them, still then, in view of the fact that the service rule does not stipulate the regularization, backdoor regularization being not a source of recruitment, they should be in the bottom of the seniority list, even if the date of seniority, date of regularization is not challenged, even if their date of regularization earlier than me. That is a series of judgments which I have relied upon. So, my Lord, even if, so my Lord, relying on that principle, yes, 18/1/2011, the date of regularization, but it is backdoor and it is an admitted fact. So in relying on those judgments, you'll be in the bottom of the seniority list. Finally, Lordship, I said, my Lord, I did not withdraw my prayer. What I have submitted, my Lord, I have submitted that in view of the judgment in Munya Toipatia, in view of the judgment in Munya Toipatia, where this honorable court has held that in view of long delay in filing the writ petition, and the fact that you have continued in service for a long period of time without interfering in the service, without interfering their regularization, you should be ranked in the bottom of the seniority list, even if the regularization was earlier than the people who were regularized, appointed in accordance with the rules. That is what the judgment says. So my respectful submission then was that my prayer, wash and set it aside is there, but if in the line of that division bench judgment, if their rank, their rank below us, I'll be satisfied. But I never made a statement that I categorically withdraw my prayers. No. Only on the basis of the legal principles, I was pointing out those judgments. So taking advantage of that, my Lord, so those are the issues, my Lord, I would like to clarify. Much obliged, Lord.
Yes, heard learned counsel for the petitioner, senior counsel for the petitioner, Mr. Takamasa, assisted by Santilo. So I've also heard Mr. Siti Jamil, learned senior counsel for respondent number 5 to 27.
27.
And learned senior government advocate, Mr. and Agami for respondent number 1, 2, 3, and 4. Hearing concluded, judgment received.
Obliged.
For hearing, item number 25.
Mr. Allen, I don't think we can,
My lord,
take this up today. Maybe next week?
my lord, actually, I may not take time, maybe only for 10-20 minutes, because
Not
I've
today.
been,
Today. Not possible today.
there's,
Lordship, my suggestion is if it is within this week, how
Hmm.
about on the 30th of this month, trustee? If not, next week.
What is the matter?
This is about the damage caused to the ROW.
Damage?
yeah,
Yes.
We are
damage,
claiming compensation.
national
Yes.
highway,
Damage compensation has been paid earlier also.
Beyond ROW.
Yes, now again, they are saying that more damage has been caused and then they are before this honorable court.
that further damage we count for that, because
After it is paid.
yeah, after acquire, they have damaged more land, further land. So that is what they affected the village and the individuals. So that is the issue that actually, suppose if the government and the concerned authority respond to the representation,
We
it
have
should not
already
come.
fixed too many cases on Thursday also.
Then next week,
Next
my
week,
lord,
next week.
yes,
Yes.
since my lord is
Uh,
next week as well.
Hmm.
If that may be
List
better
the
for
matter on 3rd,
third.
Lordship,
Fourth.
we have some other matters.
4th,
Fourth is fine.
4th
This week,
August,
Fourth or
Tuesday.
sixth.
Sixth.
6th,
You're not in my diary, yeah, maybe convenience for 6th.
6th, okay, 6th August, with the consent of the parties for hearing. Yes.
My lord, if it can, if my presence may kindly be reflected, since I am representing the NHIDCL.
Okay, okay, give all your names, huh?
Yes,
For
2, 3, 6, and
petitioner,
7.
Mr. Alan Kamer Rongme for petitioner, then Santiago for respondent
Balance 2,
number
3, 6, and 7.
2, 3, 6, and 7, and additional AG for respondent number
1, 4, 5, 8, and 9. Is that respondent? Sure.
was
Deeply obliged.
The most.